State.
Hey, Mr. Howard, how you doing?
Hey, you got the history for Vincent. I skipped him. I didn't see him on the pull sheet. He's on there, but I must have skipped him somehow.
Vincent,
Yeah.
let me check with Mr. Miss. Give me 1 second. I'm looking it up now. I'm sure we got it. Yeah, we got it, Mr. Howard. Miss McGill, she can announce that if you want her to. If you want us to send it to you, we can do that as well.
She can announce it. That's fine.
All righty.
Thank you.
Thank you.
You want me to tell you right now?
No, no, no.
Okay.
Thanks.
All right. Good afternoon, everyone. Let's go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar today, we will set bonds for those individuals recently arrested if the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding today. As you can see, I am conducting this hearing by video. I am not there in person with you. That means any member of the public can log on to this particular proceeding and watch it. It is also being recorded. When I ask if you understand your rights, this is what I am referring to. Those who receive a signature bond will be reset. Further notice. Those who receive a cash bond or a surety bond are going to our state all-purpose calendar. Ms. Bridgewater, what is my reset date?
Yes, Your Honor, it's going to be October the 14th.
So those who receive a signature or a cash bond are going to that calendar, whereby aspects of the case, including contact or the amount of the bond and other portions of the matter, can be revisited. I know that there is interpretation. Have all defense attorneys had the opportunity to interview their clients?
Yes.
All right. Can we take the interpretation case first? Has that already been, has that person been interviewed?
Your Honor, in the case of Mr. Reyes, I think he has really good English. And so I think we had a sufficient interview, and he just wanted to be able to have an interpreter for understanding court better, but I don't think he really needs it. I understand the Spanish interpreter may be here really for another case.
Okay.
Yes, I interviewed Mr. Hernandez Montenegro with an interpreter, and I requested an interpreter for court, and I'm ready when the court is.
All right, can we take those two cases first, please?
Yes, Your Honor. We can start at position 20, Mr. Hernandez Montenegro.
All right, Ms. Chancey. Oh, Ms. Chancey, please raise your right hand. Do you swear today that you will make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
Yes, Your Honor, I do.
All right. Mr. Hernandez Montenegro, your case is 25 CR 006024A.
Señor Montenegro, su número de caso es 25 CR 006024A.
You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you.
Usted tiene el derecho a guardar silencio. Todo lo que diga sobre los hechos de su caso puede y será usado en su contra.
You have a right to an attorney today, and I'm conducting this hearing by video.
Usted tiene el derecho a ser representado por un abogado y estoy conduciendo esta audiencia a través de televideo.
And in this case, you're charged with simple battery with the offense date of March the 17th.
Y usted tiene un cargo de golpes y lesiones simples con fecha del 17 de marzo.
You understand your rights and how I'm conducting this hearing today?
Señor, ¿entiende usted sus derechos y cómo yo estoy conduciendo esta audiencia hoy?
Sí.
Yes.
All right. Mr. Howard,
Señor Howard,
5 total
5 en total
on probation in Fulton for theft of lost mislaid property.
y una libertad probatoria en el condado de Fulton por robo de propiedad.
Theft by taking and criminal trespass.
También robo y allanamiento de morada.
2021 illegal alien arrest. And that's all.
Y en el 2021 un arresto por inadmisibilidad de extranjero. Y eso es todo.
all right, thank you. Ms. McGill?
Yes, Your Honor, just a little bit about the facts. This incident occurred on March 17, 2025.
Esto ocurrió el 17 de marzo del 2025. Para hablar un poco de los hechos,
Law enforcement responded to an incident that occurred at 5200 Windward Parkway, Milton, Georgia.
y la policía respondió a un incidente ocurrido en el 5200 de Windward Parkway en Milton, Georgia,
In reference to a fight.
con referencia a una pelea física.
The complainant, who is identified as Joel Millam Andog,
Y el demandante conocido como Joel Millan Andog.
Joel advised that he and Omar used to be coworkers. He advised that Omar began to accuse him of being the reason he lost his job.
Él dijo que ellos trabajaban juntos y además declaró de que Omar comenzó a acusarlo a él por ser la razón por la cual el acusado había perdido su trabajo.
So Joel advised that he attempted to walk away from him in a dispute they were having. Then Omar grabbed his shopping cart, held it in place, got in his face and spit in his face.
También el señor Joel dijo que él intentó irse caminando, alejarse de él y de la disputa que estaban teniendo. Después el señor Omar lo tomó su carrito de compras y lo sostenía para que no se moviera. Se le enfrentó y lo escupió en la cara.
The police officers witnessed video of this incident.
El oficial de policía atestiguó mirando el video de este incidente.
Given his history and his current probation cases and his status, he may be a flight risk, Your Honor. So at this point, we're asking for a $3,000 surety bond for him to stay away completely from the victim, Mr. Joel Millam Andog, and to stay away from the incident location.
Bueno, en realidad lo que se está debido a los casos que tiene anteriores de libertad probatoria, él puede ser un riesgo de huida. Su señoría, entonces en este momento estamos pidiendo una fianza de $3.000, una fianza bajo garantía, que tenga distanciamiento completo del señor y víctima Joel Milan Endog y mantenerse distanciado del lugar en donde ocurrió el incidente.
That's all.
Eso es todo.
All right, thank you. Ms. Pinto?
Thank you, Judge. Mr. Hernandez is 37 years old. He's lived in the Atlanta area for 5 years. He has two daughters, ages 9 and 12. His mother also lives here in Georgia. He did graduate high school and he's been working as a driver.
Okay, one moment, please.
Oh, I'm sorry.
Thank you. Mi cliente tiene 37 años y ha vivido en el área de Atlanta por durante 5 años. Él tiene dos niñas de edades 9 y 12. Su madre también vive aquí. Él se ha graduado de la escuela secundaria y ha estado trabajando como conductor.
He does not know the alleged victim in this case, so he's more than happy to abide by no contact and stay away orders. He reports this is his first criminal arrest.
Él ha declarado que no conoce a la víctima en este caso, entonces está con mucho gusto él va a cumplir con la orden de no tener contacto y mantenerse distanciado de como se ha ordenado. Él informa que es este su primer arresto penal.
And this is the only case I see in Odyssey as well.
Y también este es el único caso bajo su nombre en el sistema Odyssey.
Pretrial recommended a signature bond through the jail, and we would ask for the same.
Los servicios anteriores al juicio ha recomendado una fianza bajo firma a través de la cárcel y nosotros solicitamos lo mismo.
All right. Defendant is going to receive $1,000 surety bond.
Muy bien, el acusado recibirá una fianza bajo garantía de $1.000.
Let me sound for Joel Andall. Is that the name? Is that party here? The victim,
El
the alleged victim
señor
in this case?
Joel Milan Endog, la persona, está presente en la plataforma.
Okay. He's going to have no contact with that party
No
and
debe tener contacto con ese individuo
stay away from that location
y mantenerse distanciado de ese lugar del incidente.
and have no alcohol, drugs, weapons.
Se prohíbe el uso de drogas, alcohol y armas.
He'll be reset to state all purpose on the 14th.
Entonces, esto se da una nueva cita para la audiencia de casos estatales de todo tipo para el día de octubre 14.
Is there anything additional from the state or from the defense?
¿Hay algo más de la Fiscalía o la Defensa?
No, Judge.
No, su señor.
All right. Best of luck to you, sir. That concludes your case for today.
Mucha suerte, señor. Esto termina su caso por hoy.
All right. And can we take the other party that required interpretation?
Yes, Your Honor. Position 27, Reyes.
It's Jorge Reyes.
Mr. Reyes, your case is 25 CR 006067B, in which you're charged with failure to maintain lane, DUI, DUI per se, and DUI. Is that correct? How many charges are there? Hold on, 1, 2, 3 charges. So that is correct. 2 charges of DUI and 1 failure to maintain lane.
Entonces, el señor Jorge Reyes, con el caso número 25 CR 006067B, tiene 3 cargos por manejar incorrectamente sin mantenerse dentro del carril, manejar bajo los efectos del alcohol propiamente dicho y manejar bajo los efectos, incapacitado por los efectos del alcohol.
Do you understand your rights as I just explained in the last case?
¿Usted entiende los derechos que yo expliqué cuando traté el caso anterior?
Sí, lo que me acaba de decir, sí.
Yes, what you just said, yes.
Mr. Howard,
Señor
9
Ham,
total. I got 2012 DUI conviction.
yo tengo una convicción en el 2012 por manejar bajo los efectos del alcohol. 9 en total.
2006 suspended license conviction and a 2000 DUI conviction.
En el 2006, una comisión de suspensión de licencia de conducir y en el 2000, una convicción por manejar bajo los efectos del alcohol.
all right, thank you, Mr. Rhodes.
Yes, Your Honor, very briefly, this is the first in 10, but the fourth in life, as it relates to DUI.
Este es el primero en 10, pero la cuarta en toda su vida y está relacionado a manejar bajo los efectos del alcohol.
In addition to the 2012 and 2000 DUI conviction, there's also a 1999 DUI conviction.
Además de la convicción del 2012 y 2000 de las convicciones de manejar bajo los efectos del alcohol, también hay otra en 1999, que es otra convicción por manejar bajo los efectos del alcohol.
This was an implied consent where the defendant blew .241.
Esto fue con lectura del consentimiento, el documento de consentimiento explícito, en donde el acusado sopló marcando un nivel de alcohol en la sangre de .241.
As such, the state is recommending a global of $6,000 bond.
Y como la fiscalía está recomendando una fianza de $6,000 global,
5,000 on DUI per se, 500,
5,000 por manejar bajo los efectos del alcohol propiamente dicho,
500 on DUI less safe, and 500 on failure to maintain lane.
$500 por manejar incapacitado por los efectos del alcohol y $500 por no manejar dentro del carril.
We ask that as a condition of bond that he undergoes alcohol drug evaluation and treatment.
Nosotros también tomamos como condición de la fianza que él se someta a una evaluación de drogas y alcohol y tratamiento si es necesario.
And that he do not drive while out on bond unless he has been given provisional privileges to do so.
Y que no conduzca ningún vehículo mientras esté libre bajo fianza, a no ser que se le haya dado privilegios o permisos provisionales para hacerlo.
Thank you, Your Honor.
Gracias, su señoría.
All right, Mr. McLean.
Señor
You know-
McLean,
Thank you. He is a high school graduate.
él terminó la escuela secundaria,
His job for many, many years has been in construction.
ha trabajado por muchos, muchos años en la construcción.
He's been in Georgia 29 years, so he's very local with plenty of community ties and a Tyrone, Georgia address.
Él ha estado en Georgia por 29 años, por eso ha sido muy local, con muchos contactos, demasiados contactos dentro de la comunidad en Tyrone, Georgia.
So we understand about the import of the first and 10, fourth and life. and would, of course, emphasize that the last one was 2012.
Entendemos sobre el considerar el primero en 10 y cuarto durante su vida y por supuesto enfatizar que el último fue en el 2012.
I don't have an argument against ADET since it is an evaluation initially.
No tengo ningún problema por acerca de la evaluación de alcohol y drogas y tratamiento si es necesario, debido a que se inicia con una evaluación.
All right. Anything additional, Mr. McLean?
¿Algo más, señor McLean?
Ms. McLean frozen?
I think the incoming call may have messed my audio or video.
All right, was there anything else after that request, Mr. McLean?
¿Algo más, señor?
Appropriate conditions on the driving requirements, yes, and we would ask for the court to simply give him as low a bond as possible in the surety area. It doesn't look like he's going to miss court. I didn't hear any FTA. Thank you.
Así quisiéramos solicitar que la jueza simplemente le dé una fianza baja, lo más baja posible, ya que va a ser una fianza bajo garantía y no hay posibilidades de que él no se presente ante el tribunal en la próxima audiencia.
All right. Defendant is going to receive a $3,500 surety bond broken down as follows.
Y el acusado recibe una fianza bajo garantía de $3,500 que va a ser dividida de la siguiente manera.
All right. It'll be 500 count 1, 1,500 count 2, and 1,500 count 3.
Son $500 para el cargo 1, $1,500 de fianza para el cargo 2 y $1,500 para el cargo 3.
He's not to drive unless he has a valid license or permit.
Él tiene prohibido conducir un vehículo a no ser que tenga una licencia válida o permiso válido para hacerlo.
But I am not going to do the ADET at this time.
Y en este momento no voy a ordenar evaluación y tratamiento en este momento.
I'm going to reset him because he got the surety bond to the all-purpose on October the 14th.
Voy a darle una nueva fecha de comparecencia debido a que tiene una fianza bajo garantía y la próxima fecha de comparecencia es el 14 de octubre.
Is there anything additional from the state or from the defense?
No,
¿Hay
Your
algo más?
And from the state, Your Honor. Thank you.
No.
All right, best of luck to you, Mr. Reyes. That concludes your case.
La mejor de las suertes para usted, señor Reyes. Esto concluye su caso hoy.
All right, Miss Chancey, will you please sound before you leave us?
Yes, ma'am. ¿Hay alguien que necesite la asistencia de un intérprete en español para hablar con la señora jueza? Por favor, prenda su micrófono y avísenos. Y su cámara también.
All right, hearing none. Thank you, Miss Chancey. Have a good afternoon.
You're welcome, you to your honor. Have a good day.
Bye-bye.
Your Honor, we can go to position 10, Mr. Buford.
That's my case, Judge.
Good afternoon, Mr. Murphy.
Good
All
afternoon.
right, Mr. Buford, your case is 25 CR 006061B. You're charged with 2 counts of escape, 2 counts of interference with government property, 3 counts of that, 1 count of simple battery, and 1 count of theft by taking. Do you understand your rights today? Is that a yes?
Yes, ma'am, I do.
Thank
Your Honor,
you.
apologies. Before you proceed any further, this is there were 4 individuals arrested for joint conduct in this case. If we could we handle them together?
I have no objection to that. That's fine. We'll take them one at a time. All right, Mr. Howard.
He has a probation hold on probation for ag assault. 2017 trespass conviction. 2014 battery DV conviction. 2016 FTA.
All right, thank you, Mr. Sirocco.
Thank you, Your Honor. This was a Rice Street jail incident. This is from September 28th to the 29th. The defendant, along with several other individuals, Sherman Bell, Melvin Williams, um, the four were, excuse me, those three were observed surrounding a Mr. Terrell Gaskin in a heated verbal exchange. I believe Mr. Gaskin is another inmate at Rice Street. The three were, excuse me, the three individuals had struck Mr. Gaskin multiple times with a closed fist to his face, upper torso, and back. He managed to run away from them and get into a utility closet. But to get to Mr. Gaskill, these individuals broke the Zone 100 door off its sliding tracks to escape out of the Zone 100 pod. Also broke the Zone 800 door off the sliding tracks to break into where Terrell Gaskin was located. And just as well, it was discovered that these individuals, in addition to the fourth individual that I mentioned, who's Michael Williams III, had stolen food items from the it was they'd broken one of the zone doors off to steal food items from one of the deputies there, and that was in Zone 700. And yeah, and that involved the breaking of the Zone 100 door. Um, so these are the bases for the charges here today for multiple individuals. This defendant has a robust history. He's currently being held on a probation violation 25 PV 002000. It's for a felony case, and there are a number of arrests for there's an arrest for aggravated assault, armed robbery, receipt, possession, transport of firearm by convicted felon from 2022. That case was ultimately dismissed. There was a simple battery from 2024 that was dismissed. A number of violent cases, and he's currently on probation. I believe pretrial mentioned that for ag assault, 2 counts, possession of firearm or knife during commission. He was convicted in 2024 of that. The state's recommendation here, given the history and the open case that he's also being held on, along with the violence and the risk for reoffense, would be 3,500 total surety, 500 on each count. No further contact with Terrell Gaskin. We would ask that the jail separate the defendant and the victim, and no drugs, weapons, or alcohol while out on bond. That is all for the state.
Okay. Mr. Murphy?
Judge, it appears that has a felony probation hold. He's probably going to face some sort of additional sanction. I'd ask the court to consider a reasonable bond. I would say in the amount of half what the state is proposing.
All right, defendant is going to receive a $1,500 surety bond. That should be $250 on each count. Let me double check. Yep. He is to have no alcohol, drugs, or weapons and have no contact with Mr. Gaskin. To the best of the jail's ability, those two parties should remain separated. And he is to have no alcohol, drugs, or weapons. His case will be reset to October the 14th. Is there anything additional from the state of the defense?
None, Your Honor.
None from the defense.
Okay, you have a question? Is it about the bond very quickly, sir?
Yeah, I was trying to see could I just play out to it today.
Mr. Buford, let's look at everything you're already held there, and then we'll decide.
Your attorney will speak with you further, okay?
I want to do though.
All right. Before we go on, the gentleman who was at Street's iPad, Sir, what is your name and what case are you here for?
Are you talking to me?
No, is your name Streets iPad?
Oh, no, no, no.
Then that's not you. Streets iPad.
Yes.
Sir, what case are you here for?
Um, the case against Cook.
Okay, we'll hold for that. All right, just wanted to check.
Right.
Are there any other private attorneys on the screen? Okay, hearing none, can we go to the rest of the individuals charged with this escape?
Honor, how much was that bond?
1,500, 250 on each count.
All right, I calculated 1750.
Oh, maybe I have 6 counts. How many counts? Wait, 1, 2, 3,
There's
4.
7 counts, Your Honor.
Oh, then that might be what the difference is. Hold on. And I'm bad at math, so I don't proclaim to 1, 2, 3, 4. I'm gonna use a calculator just to make sure. And don't laugh at me. Okay, then it is 1750. I originally had 6 counts.
Thank you, Judge.
All right. All right. And Mr. Murphy, do you have other cases today?
I do have 5 more.
Okay. All right. Thank you.
All right.
All right.
Position 41, Mr. Williams, Melvin Williams.
All right, Mr. Williams, your case is 25 CR 006055H. You're charged with escape, 2 counts, 3 counts of interference with government property, simple battery, and theft by taking. Do you understand your rights today?
No.
All right, Mr. Howard, can I have his history, please?
Melvin. 5 on probation, out of COB, entering auto. First offender probation in Fulton, theft by taking, criminal damage to property, 2nd degree. And yeah, the felony charge as well. That's it.
All right, thank you. Mr. Sirocco, we're familiar with the facts.
Yes, Your Honor, and I just would supplement with respect to his history. He's currently being held on several felony offenses. 25 PI 007534 is receipt, possession, transport of firearm by convicted felon and simple battery, family violence, and 25 PI 007917 is those are aggravated assault and riot in a penal institution, and I believe that was from now last month. He had attacked a fellow inmate, a different victim, with a sharp object, and that victim was found lying on the ground in a pool of blood, as well as an open FTA, 25 FTA 0001759. So there is clearly a risk of failing to appear, in addition to the obvious risk of reoffense here. We are asking for an $8,000 total surety. We are asking for $5,000 on the simple battery, $500 for the remaining 6 charges, the other ones, and no further contact with Terrell Gaskin, excuse me. We would ask that the jail, again, separate the defendant from the victim here, and that the defendant have no drugs, weapons, or alcohol while out on bond.
All right, thank you. Who represents this defendant?
Your Honor, he elected to go pro se instead of waiting for another conflict attorney.
Okay, so what we're gonna do is defendant is gonna receive that same bond, 1750, 250 on each count. He's to have no contact with the alleged victim to the best of the jail's ability, and he'll be reset to October the 14th, whereby aspects of the case can be revisited. Mr. Williams, best of luck to you. That concludes your case for today. All right, who do we have next?
Position 43, Mr. Williams, Michael Williams.
All right, Mr. Williams, is he coming? Your case is 25 CR 006054E. You're charged with this is a little different. Okay, so he's got escape, Interference with government property and theft by taking. You understand your rights today?
Ma'am.
All right, Mr. Howard.
Michael, 17. He got an open simple assault, Superior Court. 2024 probation, 2022 probation. 2019 theft by taking, first offender. 2019 disorderly conduct conviction. 2016 simple assault obstruction conviction. That's it.
Okay, thank you, Mrs. Sirocco.
Thank you, Your Honor. And I would add as well, he does have an open case. It's technically in our office right now. It's 25 CR 006-017E, and that is for battery, family violence. It's among other charges. That case has now been accepted as an aggravated assault strangulation. So I have sent to the court a transfer order for Your Honor's signature for that, if you'd be so kind. And just as well with this case, it's a little bit different because the defendant was not involved in the breaking of the zone 800 or 700, zone 800 door, and nor the beating of Mr. Gaskin. This was just the theft, the escape through of confinement into unauthorized area, and the theft of the deputies' food items there. The state's recommendation is a $1,500 surety, $500 for each count. No drugs, weapons, or alcohol while out on bond. And that is all for the state on this case.
All right, I'm assuming Mr. Williams is going pro se as well. Is that correct?
Yes, Your Honor.
All right, so there's 3 counts. Defendant is going to receive $1,000 surety bond, 500 on count 1, 250 on each remaining count. He's to have no alcohol, drugs, weapons, and will be reset to state all purpose on the 14th. Anything additional, Mr. Sirocco?
Nope, that is all, Your Honor. Thank you.
All right, best of luck to you, Mr. Williams. That concludes your case for today.
Thank you.
Next is position 4, Ms. Blake.
Okay, have we finished with everybody involved in the escape?
We haven't dealt with Mr. Bell's case yet.
Yes, he decided to wait till Friday for another conflict attorney.
Okay. All right. I don't know if that was wired for same, but okay. All right. So Ms. Blake, your case is 25 CR 006047B. You're charged with making an illegal stop, driving with your suspended license, fleeing or attempting to elude, and failure to obey a traffic control device. Do you understand your rights today? Is that a yes? All right. Thank you, Mr. Howard.
Can you hear me?
I'm sorry. Say that again.
Blake, third arrest, 2024 obstruction, 2023 inflict corporal injury on spouse or cohabitant. That's California. That's all.
All right. Thank you, Mr. Rhodes.
Yes, Your Honor. As it relates to this incident, it occurred September 30th of this year. Officer Salters observed a black 2025 Mazda CX-30 illegally parked in front of 848 Peachtree Street. When officers went to ticket the vehicle for being illegally parked, he was encountered by Ms. Blake, who returned screaming at him, stating that the police was always messing with her. Officers did ask her if she wanted to move her vehicle. Instead of moving the vehicle, Ms. Blake went back inside of the businesses, inside of the location outside of the illegal parking and towaway zone. So officers did intend to tow the vehicle. Before the tow truck could actually get there, she did get inside of the vehicle and attempted to pull off. When officers questioned her, she disregarded their questions, and essentially they found out that when they ran the tags, that her license was in fact suspended on September 26th of 2025 due to a failure to appear, Your Honor. So it's basically she pulled away despite them turning on their emergency lights. And she made multiple U-turns and she would not stop for these officers. And she was on Peachtree Street, a very busy street, as you can imagine. And so officers did have to call more units to assist with this particular arrest. Your Honor, for that reason, Your Honor, and because of the seriousness of it, I am asking for a good bond in the amount of $4,000. I am asking for a $2,000 on count 1 and $1,000 on the remaining counts respectively. And ask that because we know her license is suspended, that she is not to drive or operate a motor vehicle that requires a license.
Okay.
And no alcohol, drugs, and weapons while out on bond. Thank you, Judge.
Thank you. Ms. Pinto?
Thank you, Judge. Miss Blake is 29 years old. She's lived in Atlanta recently for about a year, but she is from here originally as well. All of her immediate family are in Georgia. She's a graduate of Westlake High School. Her job is driving for DoorDash. She's been doing that for about 6 months. Pretrial reports, no failures to appear, no prior convictions. I will note that Miss Blake denies the allegations and specifically says that her license was not suspended, that there was no court date on the 26th. So I understand if the court wants to impose a no driving if license is suspended, but we would ask that have to be confirmed in order for that to be in effect. Pretrial recommended a signature bond through the jail, and we would ask for the same.
All right, defendant's going to receive $1,000 surety bond, $250 on each count. She's not to drive unless she has a valid license issued by the state of Georgia. She's to have no alcohol, no drugs, no weapons as a condition, and she'll be reset to all purpose on the 14th. Is there anything additional from the state or from the defense?
Nothing further. Thank you, Your Honor.
All right, best of luck to you, Ms. Blake. Who do we have next?
Good afternoon, Judge.
Good afternoon.
If you can please read the rights, and then I have position number 1, Ms. Tracy Allen.
Thank you. Good afternoon at ACDC. Ms. Allen and all defendants, please pay attention closely to these rights as I explain them to Ms. Allen. Ms. Allen, your case is 25 CR 006023G. In this case, you're charged with 2 counts of battery, family violence, and 2 counts of simple. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I am conducting this hearing by video, and it's being live streamed and recorded. That means any member of the public can log on and watch this particular proceeding. Do you understand your rights and how I'm conducting the hearing today? Thank you, Mr. Howard.
What's the last name?
It's position 1, Allen.
Oh, 11. I saw a 2025 DUI suspended license, drug-related objects. 2020 battery DV dismissed. 1 is fine.
Okay. Thank you. Ms. McGill?
Yes, Your Honor. To supplement what was told to you, she does have an open case for a DUI that was bound over to Fulton County State Court on May 19th of this year. And she also may have it looks like an open case for the DUI and possession of drugs from August 15th of this year. A little bit about this incident. Police responded to a domestic call from the victim, Izra Tadesse, Izratadesse. He informed law enforcement that they met up and had a few drinks at a local bar. When Miss Allen arrived, he noticed that she had already been drinking. Later, they left the bar and returned home. Once home, they got into a verbal dispute over something small. Miss Allen grabbed Mr. Tadesse's necklace and backed him up against the wall, then tells him to get his things and to leave. Before he could reply, she snatched his necklace off, leaving him with scratches on his neck. He began to yell at her to stop while asking, what was wrong with her. During the scuffle, she broke several beaded bracelets and left scratches on his wrist. With the open cases and her history, we are asking for a $3,000 secure bond to have no further contact with the victim in this case. That she undergo an alcohol drug assessment and evaluation and treatment, that she consumed no alcohol or drugs while out on bond. And we do think it's appropriate that she actually be screened for drugs and alcohol, given her open DUI cases. As far as the victim is concerned, he does live at the incident location, which is 1244 D4 Village Court, Northwest Atlanta, Georgia, Unit 438. And he needs about 30 days to move out. They are roommates, so we are asking for a stay away from that incident location for at least 30 days until he moves out.
Okay, I'm sorry, his name again was?
It is Izra, Izra, last name Tedessi, Tadesse.
All right, is that party on the line? Israel Tedessi?
Yes, ma'am.
All right, if you'd like to make a statement, please turn on your camera and raise your right hand. You're not required to, however.
Hold on 1 second. Oh,
All right, and sit back a little bit so we can see you clearly. Thank you. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
yes, ma'am.
All right, thank you. Let me give you some very brief instructions before you proceed. I'm going to hear from you, but what I'm most concerned with today is your desire for contact with the defendant in this case and any concerns you have about your safety. Whether you are concerned, whether you disagree with the facts as just set forth by Ms. McGill, that's not what I'm most concerned about. There'll be other proceedings where we can flesh that out, okay? So in light of those instructions, what would you like to tell me?
Well, that I am moving out. I don't, within the 30 days they gave me, or they told me. I do feel like she needs to maybe chill out on all this stuff on her. I don't know. I've never done this before, so I apologize. I guess I really don't have anything to say. I just want to make sure I'm safe and okay, and it's just, yeah, I don't know, ma'am. I'm sorry. Like
Right.
I feel like I just want to make sure I'm safe and everything's okay, and that yeah, and she did grab my neck and threw me against the wall, and which she's not a big person, but like, and then ripped off my mother's ashes, all this stuff. I don't know. It was a lot. It was just a very traumatizing incident, and so I might need a TPO for.
All right, you did a good job. I appreciate you coming to court and making that statement, okay?
Thank you. Sorry, I'm at work right now, so it's like taking so
You did a
much.
good job. All right,
Okay.
and I'm sure someone else will be in touch with you as the case progresses, okay?
Okay.
All right. All right, Mr. Murphy, is this your case?
That's my case, Judge.
Oh, it's yours. I'm sorry, Ms. Pinto. Please proceed.
Thank you. Miss Allen is 41 years old. She's lived in Atlanta her entire life. She does have 2 children, ages 16 and 12. Most of her family is here in Georgia. She did do some college at West Georgia College and West Central. She just got a new job at Top Golf, and she's supposed to start in 2 weeks there. I will note that, we deny the allegations. Ms. Allen notes that the alleged victim, it was not supposed to even be at the property. And the apartment complex is in the process of moving him out. She does have another place she can stay with her boyfriend on Moreland Avenue in order to abide by any no contact orders that the state or the court wants to impose. But that address, that incident location address, is her address. And she would like to return there when able. Pretrial reports no failures to appear, so there's no reason to think she wouldn't come to court. And they recommend a signature bond at supervision level 1. We would ask the court for a signature bond or a bond not to exceed $1,000.
All right. All right. Defendant is going to receive a $4,000 signature bond at level 1 through pretrial services. She's to have no contact whatsoever with the alleged victim in this case. I am going to order the stay away until the alleged victim has moved out. She can return one time with a member of law enforcement to ascertain whether the defendant is gone. If he's still there, she must stay away and collect her items. If he's moved out, she can return to the location. She's also going to take a 1-day anger awareness course, and she's to have absolutely no alcohol, drugs, or weapons. And because she's receiving the signature bond through pretrial services, she will be reset for the notice. Is there anything additional from the state or defense?
No, Judge.
All right, here, back to you, Ms. Allen. This, your case is concluded for today.
Next is 6, Ms. Brown. Desiree Brown.
Okay, thank you. Ms. Brown, your case is 25 CR 006046G. You're charged with simple battery family violence in this case. Do you understand your rights?
First.
Is that a yes? All right, I'm assuming that's a yes. We'll go to Mr. Rhodes. Mr. Rhodes, if you're speaking, you're muted.
Sorry about that, Judge. 2000 SOB pretrial services level 1. At this time, we just asked for, we asked for no further violent contact with Dominique Hamilton. No weapons, drugs, or alcohol while on bond. Thank you, Judge.
All right, I'm a sound for Dominique Hamilton. Is Dominique
They got arrested too, right?
Yes.
It's a cross arrest?
Yes, that's position 18.
Oh, okay. So that seems like that would be prudent. Let me look at the warrant very quickly to make sure I don't see anything. All right. Mr. Murphy, this is your client, or is this Ms. Pinto?
Ms. Brown is my client.
Okay, Ms. Pinto, do you object to a signature bond through pretrial services with a no further violent contact and a 1-day anger awareness?
Well, Your Honor, we do ask for a signature bond. We would ask that it be through the jail, which is also what pretrial recommended.
It's a violent offense, so I will not be sending it through the jail pursuant to the bail restricted legislation.
Understood,
And
Judge.
that's why I didn't recommend UJR, Your Honor, because of the family violence component.
And she is okay with any stayaways and no contact orders imposed by the court.
All right. Defendant is going to receive a $2,500 signature bond through pretrial services at level 1. She's to have no further violent contact with Dominique Hamilton. She is going to take a 1-day anger awareness course and have no alcohol, drugs, weapons, and will be reset for the notice. Is there anything additional?
Nothing from the
No,
state.
Judge.
All right. Best of luck to you, Ms. Brown. That concludes your case for today. Who do we have next?
Position number 2, Siobhan Allen.
Oh, yeah. Okay. All right, Ms. Allen, your case is 25 CR 006060C. You're charged with simple battery against a person who was either 65 years older or who was pregnant, and simple battery family violence. Do you understand your rights today? All right, Mr. Howard.
17, 2022, 2021, failure to appear. 2022, shoplifting conviction. 19, simple battery DV. 2014, criminal damage to property, 2nd degree, felony obstruction. 2010, simple battery, felony obstruction. And a 2010 ag assault, first offender.
All right, thank you. Whose case is this for the state? Ms. McGill, please proceed.
Yes, Your Honor. Just a little bit about the facts. Police responded to a call from the defendant's mother, Miss Carol Allen, stating that her daughter and her had gotten into a fight. and that her daughter started hitting her, basically. She didn't have any marks on her face, but Miss Carroll did advise that she wants her daughter to get some help. She advised that there are some mental health issues and that she does have a mental health diagnosis. Given her history and of family violence and just her overall history, we are recommending a $2,000 secured bond, that she have no further contact with the victim, Miss Carol Allen, that she stay away from the incident location, being 636 Willard Avenue, Southwest Atlanta, Georgia, in Fulton County, and that she take a anger awareness course, Your Honor.
Thank you. And is Miss Carol Allen present?
We're also, sorry, we're recommending a mental health evaluation and treatment as well.
All right, thank you. Ms. Pinto?
Thank you, Judge. Sorry, excuse me. Miss Allen's 45 years old. She's lived in the Atlanta area her entire life. She does have children who are all grown at this point. Her whole family is here in Georgia. She did go to the 10th grade. Prior to her arrest, she was working doing private home care for elderly patients. She was doing that for about 6 months. She is okay with no contact and with the alleged victim and to stay away. She has somewhere that she could go at a friend's house. We are asking the court for a signature bond. Miss Allen has been in custody on a different case since April. And then she resolved that case, and then this popped up, even though the warrant, I think, had been out there since the alleged incident. So she's been in custody for 159 days. She has no way to post a monetary bond. I will note there are 2 counts, but it's just one incident and one alleged victim. So we would ask the court to give a signature bond so that Miss Allen can finally return to her life.
So she was bonding out on something else and then this arose? Is that what happened? Or this was...
She actually resolved the other case that she was in jail on. She was supposed to go on probation. And then as she was getting ready to do that, the jail informed her that she now had this warrant and was going to be held on this.
Okay, hold on. Let me look at one thing. And she took a plea in that case, Ms. Pinto?
Yes.
Do you have that case number?
I can pull it up, Judge. It was actually, I think, the same date, but different alleged victims. So originally I thought this was just one case, but because it's different alleged victims,
okay,
it's 25SC003560.
okay. All right, I'm not gonna give her a signature bond, but what I'm gonna do, I'll make it $1,000 surety bond, 500 on each count with no contact with the alleged victim in this case and a stay away. She's to have no alcohol, drugs, or weapons. Can we, Miss Bridgewater?
Yes, ma'am.
Is there room on a sooner one?
I'm sorry.
Did you lose me for a minute? Can you hear me?
I can hear you, Your Honor, if you're talking.
Okay. Yes, Ms. Bridgewater, I was asking, could I put her on a sooner SAP? Is there more space on perhaps next week versus all the way to the 14th?
Okay, it will be the 7th then.
Okay, her case is reset October 7th. All right. Best of luck to you, ma'am. That concludes your case for today.
Yeah, you said 1,000 surety, correct?
That's correct.
Thank you.
All right. Who do we have next?
Position 8, Miss Brown. She's going pro se.
Okay, Ms. Brown, your case is 25 CR 006048E. You're charged with simple battery, family violence. You understand your rights today? All right. Mr. Howard?
L. Brown. I got first arrest.
Okay, I'm making sure. Mr. Rhodes?
Yeah, she's companion with the Brown that we just did. It is also a signature bond level one through pretrial services and no further violent contact with the Dominique Hamilton.
Okay.
Thank you, John.
Let me glance over the warrant very quickly again. And at this time, I'm sounding for Dominique Hamilton again, even though they were not present for the previous case.
She's on the calendar. She's the
Oh,
third.
that's right. I'm
They're
sorry.
all siblings, three sisters.
There's a lot of people on this calendar today and a lot to remember. All right, defendant is going to receive a $2,500 signature bond through pretrial services at level 1. She's going to take the 1-day anger awareness course and have no further violent contact with Dominique Hamilton, have no alcohol, drugs, or weapons, and will be reset further notice. Is there anything additional?
That's my mistake.
All right, best of luck to you, ma'am. That concludes your case for today.
Number 32, Sneeze.
Number what?
32.
32.
All right, ma'am. Ms. Sneeze, your case is 25 CR 006041B. You're charged with simple assault, family violence. You understand your rights today?
Yeah.
All right, thank you, Mr. Howard.
Third. 2019 battery contributing to delinquency of a minor. That was dismissed. And had a 2004 arrest that was dismissed. That's it.
All right, thank you, Mr. Sirocco.
Thank you, Your Honor. This incident took place, this was yesterday, at 3523 Forest Park in Atlanta, Forest Park Road in Atlanta. Law enforcement responded there in reference to a domestic dispute call and made contact with the victim in this case, Miss Danielle Sneeze. It's the defendant's daughter who resides at the location. There was a heated argument between them. And that situation escalated when her mother retrieved a handgun and continued to argue with her in a threatening manner. She effectively stated, "You need to leave my house before I do something to you." She was in fear for her safety and she left the premises. The defendant acknowledged that a firearm was present in the home, claimed it belonged to her husband. That husband confirmed ownership of the handgun and confirmed ownership of the handgun and granted officers permission to enter the home. They retrieved the weapon, which matched the description of the weapon as provided by the victim. I see that battery substantial physical harm from 2019 was a conviction. There was also a contributing to delinquency or dependency of a minor charge that was null pros with that. As you know, Your Honor, the state takes firearms charges very, very seriously. We are concerned for this victim's safety. We have not spoken with the victim in this case. And out of an abundance of caution, we would ask for no further contact with Danielle Sneeze. In total here, the state is seeking a $7,000 surety bond for the defendant to enroll in and complete FFIB, have no further contact with Danielle Sneeze, stay away from the incident location. That's 3523 Forest Park Road Southeast in Atlanta. No drugs, weapons, or alcohol while out on bond. And we would ask that any firearms in or around the defendant's possession, that they be surrendered to the sheriff's office. That is all for the state. If we could sound for Miss Sneeze, and yep, that is it. Thank you.
All right, is Miss Danielle Sneeze present? Okay. Mr. Murphy, is this your case? Or is this Ms. Pinto? Or is this defendant going pro se? No one represents this
Not
defendant?
mine, Judge. I think it might be Mr. McLean.
Hang on.
Yeah, no.
What number? I was just
30, number 32.
32. Let me use the thing to flip forward. Okay. Yes, I did interview that client at ACDC, Your Honor.
All right, Mr. McLean, please proceed. Mr. Sirocco is requesting, I believe, a $7,000 bond.
That's correct, Your Honor.
Okay. Let's see. Right here. Let's see. If you'll give me just a second, I've got. We're asking for the court to consider a signature bond. My understanding of the priors were that there was a charge about 5 or 6 years ago, and there are community contacts here. So we're simply asking for the court to grant a signature bond.
All right. Defendant is going to receive a $1,000 surety bond. She's to have no contact with the alleged victim in this case and stay away from that location. She can return one time with a member of law enforcement to get any items should she need to do so. And she's to have no alcohol, drugs, or weapons. And she's to surrender any firearms to the Fulton County Sheriff that she may have. Because the case is going to be reset to the October 14th all-purpose calendar, whereby aspects of the case, including that contact, can be revisited. Is there anything additional?
Nothing additional, thank you.
All right, best of luck to you, sir. Who do we have next?
Position 5, Ms. Bradley.
That's my case, Judge.
Okay, thank you. You said Ms. Bradley, position 5?
Yes, Judge.
Thank you. Ms. Bradley, your case is 25 CR 006045Y. You're charged with simple battery in this case. You understand your rights?
Yes.
All right, Mr. Howard.
20 total on probation, simple assault, family violence, trespass. You want the case numbers?
No, not that one. I don't need that
Good.
one.
Open battery DV, trespass damage in state court. 2020 failure to appear. 2019 ag assault, giving false name. Cruelty in the third conviction. I got a 2013 ag assault conviction. I'll leave it at that.
All right, thank you, Mr. Rhodes.
Yes, Your Honor. Against my better judgment, I am asking for a $2,000 signature bond through pretrial services level 2. This is another cross complaint. The other party involved in this is a Wayre Melson, I believe Melson with an M. So we're going to ask for, at this time, that there be no further contact with Wayre, W-A-Y-R-E-E, Melson, spelled with an M and not an N, as in Nancy, and to stay away from 55 Hilliard Street, Southeast in Atlanta, Georgia.
Okay.
Yep.
And that defendant was on the felony calendar or is on this calendar?
Should be on this calendar, Your Honor. He was also charged, instead of being charged with simple battery like Miss Bradley was, he's charged with battery.
He bonded out.
Oh, he did bond.
Okay, okay. All right, Mr. Murphy.
Judge, my client received serious injury as a result of this incident with that gentleman. We'd ask for to concur with the $2,500 signature bond. She is vested in the community. The address that the state gave, Mr. Rhodes gave, that's actually her residence, not the co-defendants or cross-defendants. So I'd ask for her to be allowed to go back to her residence. She is in cosmetic sales. She is self-employed. So she needs to maintain some sort of cash flow and also tend to her injuries. She was treated. She needs to follow up with her own physician as to her injuries. And again, she will follow the directives of the court and stay away from Mr. Melson. I certainly would think that the result of her injuries would keep her clear of him. But Judge, we'd ask that the court factor that in, again, allow her to go back to Hilliard Street, Unit 219. That is her apartment.
Yeah, and not to belabor, but the warrant, and I believe Your Honor does have a copy of the warrant, indicates that that the property manager at 55 Hilliard Street Southeast, the property manager by the name of Mr. Quincy asked Mr. Melson to tell Ms. Bradley to leave the property because she was a disturbance. So you know, I don't have any leasing information, but that leads me to believe that it was Mr. Melson's property. Uh, so at this juncture, I ask that she stay away.
Judge, I won't contend what the state is stating at that point. She'll have to resolve that independently then, Judge. And then if she needs to retrieve anything, she knows to get law enforcement to escort her.
All right. Defendant's going to receive a $2,500 signature bond at level 2 through pretrial services per judge. She is going to have no contact with Mr. Melson and stay away from that location. She can return one time with a member of law enforcement to get any items. She's also going to take that 1-day anger awareness course. She's to have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
Nothing from the state. Thank you, Judge.
Thank you. Best of luck to you, ma'am. Mr. Murphy, were you saying something? Did I cut you off?
No, Judge, that's all I had, Your Honor. Thank you, Your Honor.
Thank you,
All
Mr.
right.
Murphy.
Thank you.
Number 36, Strong.
Before we do that, Mr. Murphy, you have how many left?
Judge, I have 4 more left.
Okay. Is it possible? Can we do all of Mr. Murphy's cases? Is that possible?
That's possible.
Judge, we should just go to position 18 next. That's Miss Hamilton with the co-defendants.
Okay. Okay, Ms. Hamilton, your case is 25 CR 006049F. You're charged with simple battery in this case. You understand your rights? Is that a yes? All right, Mr. Howard.
Third, got an open simple battery in state court. It's 25 CR 006049F. And the 2015 battery and trespass out of Clayton County, that one was dismissed.
Okay, thank you, Mr. Rose.
Yes, Your Honor. Again, against my better judgment, I am going to ask for a $3,000 signature bond instead of level 1 a level 2 supervision because of the open case. In the prior other cycles, Your Honor, were cases of violence as well. So I am going to ask for level 2 supervision for her and that she has no further violent contact with her sisters. One is by the name of Lucretia Brown, and the other one is Desiree Brown, who were both co-defendants. She is the cross-defendant, Miss Hamilton is. Thank you, Judge.
All right, Mr. Murphy, if you object, I'll allow you to lodge those objections, but my ruling as follows. Defendant is going to receive a $5,000 signature bond at level 2 per judge through pretrial services. She's to have no further violent contact with either of the cross defendants, and she's going to take the 2-day anger awareness course, have no alcohol, drugs, or weapons, and will be reset for the notice. Any objections, Mr. Murphy?
No, Judge, I did want to note that the incident location is 4300 Flat Shoals Road, apartment 706 in Union City. My client indicates that that's her apartment. The cross defense or the other co-defendants do not reside there. So we certainly want that to be factored in. She should be able to go back to her residence. And we pretty much will.
Well, I didn't put in a stay away because it's no further violent contact. So I think we're okay on that, Mr. Murphy.
Okay, duly noted, Judge.
And I didn't ask for a stay away. Did she want to stay away, Mr. Murphy? So just in case.
She wanted them to stay away, and they can just go get a sheriff or a third party.
What we're gonna do is we're just gonna stay out of that. No further violent contact. Everybody behave themselves, and hopefully we don't get back in trouble with this point. All right, and we're gonna learn something in that 2-day anger awareness course on how to conduct ourselves. All right. Best of luck to you, Ms. Hamilton. Take care. All right, can we take the next of Mr. Murphy's positions, whichever one is most convenient? All right, who's at courtroom 2?
Position 23.
All right, is this Jody Iraldo? Miss Iraldo, your case is 25 CR 006035A. You're charged with battery family violence. You understand your rights today? All right, I see you nodding, Mr. Howard.
Last arrest was a 2013 traffic offense. That's all.
All right, thank you. Whose case is this for the state?
Yes, Your Honor, this is Rose. I'm going to ask for I do concur with what I'm seeing. This is Miss Jody Araldo.
Yes.
Yes, the state's asking for a $3,000 sign-on bond to pretrial services level 1. We are asking at this time that she has no further contact with Marlon Hutchinson and to stay away from 2878 Delow Drive in East Point, Georgia 30344. I do believe that we tried to get in contact with Mr. Hutchinson. If he is on and his desires are different, then we can sound for him, Your Honor.
All right, is Mr. Hutchinson present? Hearing and seeing none, Mr. Murphy?
Judge, my client is age 63. She's spent 2 days in jail. I would describe this as a bit of a torrid relationship. She certainly will not return there. She's currently unemployed. So again, we'd ask the court to consider a signature bond. She does have family in the area, and she's going to need a one-time escort to retrieve her belongings. And she's advised the court judge she has some family contacts for me to reach out to, but she was hoping that a social worker could speak with her perhaps today, because there is the possibility of a housing issue, because she was residing with this gentleman and it was his residence.
Okay. I believe because she's represented by you, Mr. Murphy, the public defenders, social workers are not able to interface with her. But defendant will receive a $3,000 signature bond through pretrial services at level 1. She's to have no contact with Mr. Hutchinson and stay away from that address on Delow Drive. She can return one time with law enforcement to get any items. She's to have no alcohol, drugs, weapons, and she is going to be reset for the notice. Is there anything additional?
Nothing from the state, Your Honor.
All right. Best of luck to you, ma'am. That concludes your case for today. Who do we have next?
Position 25, Mr. King.
Mr. King, your case is 25 CR 006036A. You're charged with pandering with the offense date of, does it say January 19th? Do you understand your rights? All right, Mr. Howard.
Yeah. Hold on.
It's
17
it's
total.
older.
Last arrest was 07, simple battery.
Yeah.
Okay. Mr. Sirocco, please proceed.
Yes, Your Honor. Mr. Murphy, I'm not sure if you want to just waive reading of the facts here, given the nature of the charge and
Yes.
Let me take a look. Okay, I'm fine with the waiver.
All right. Your Honor, the state's recommendation here is a signature bond through pretrial services. No further contact with a Miss Rashenda Weaver, and no drugs, weapons, or alcohol while out on bond. That is it for the state.
Is Rashonda Weaver present? Mr. Murphy?
Judge, my client's age 67, doesn't have any recent history. He's been in custody 2 days. He was unaware of this case. He thought he had been exonerated because he had provided testimony for the district attorney's office some time ago, and he was pulled over on a routine traffic stop, and that's when this warrant popped up. So he's been in custody 2 days. He certainly will stay away from this person. This alleged person was prosecuted in Superior Court. My client has ties to the community, and he certainly will report to court. And I will stay on the matter until the matter is resolved, Judge. So we'd ask that you allow a signature bond so he can be released today.
All right, I'm gonna give defendant $1 cash bond. He's to have no contact with Ms. Rashonda Weaver and have no alcohol, drugs, weapons. And because it is $1 cash, he's gonna be reset to the all-purpose calendar on the 14th. Is there anything additional?
Nothing from the state, Your Honor.
All right, best of luck to you, Mr. King. Who do we have next?
Mission 35, Mr. Stanley.
Okay, Mr. Stanley, your case is 25 CR 006025E. You're charged with criminal trespass and damage to property. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
2024 forgery in the first, 2009 violation of family violence order conviction. That's it.
All right, thank you. Whose case is this for the state?
Mine, Judge.
All right, please proceed, Ms. McGill.
Yes, Your Honor. Just briefly about the facts, it is alleged that on July 30th, 2025, at 715 Peoples Street, Southwest Atlanta, Georgia, the defendant did break the windshield wipers of Miss Sonia Hurd's vehicle. Miss Hurd witnessed the defendant damage the rear wiper and noticed that the front wiper, was damaged as well. Given the extensive history of Mr. Stanley, we are asking for a $1,000 surety bond to have no further contact with Miss Sonia Hurd, to stay away from the incident location, that he not consume any alcohol or drugs while out on bond. And
okay, let's sound for Ms. Hurd. Is Ms. Hurd present and wishes to make a statement? I see you, Ms. Hurd. If you wish to make a statement, you're not required to. Please unmute and raise your right hand.
Okay. Am I unmuted?
You're unmuted. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
Mr. Stanley has been drinking on me, and this is not my first offense. This is the third time that he messed with my car. And as you said, I not want him to see me anymore. And during his alcohol and stuff, he working at this liquor store, and I suggest he not be there. And I'd like to get him some help.
All right. Thank you, Ms. Hurd. I appreciate you coming to court and making that statement. Mr. Murphy?
Judge, my client's age 63. He's vested in the community. He's originally from Tifton, Georgia, but he's resided in Atlanta for approximately since 2010. He has no other discernible assets. He's waiting on a Social Security claim, and he has a part-time job, which does not provide a lot in the way of funds. He'll certainly stay away from Ms. Hurd. I've got other people to reach out to make sure that he has a place to stay. So we'd ask the court to consider a signature bond therein, given his age and lack of assets.
Give me 1 second to look up one thing. Bear with me. All right, defendant is going to receive a $5 cash fine. He's to have no contact whatsoever with Ms. Hurd, stay away from that location, and have no alcohol, drugs, or weapons. He is going to be reset to all purpose on the 14th in light of that cash fine. Is there anything additional from the state of defense?
How much was that?
$5 in cash. All right. Hearing none, best of luck to you, sir. Mr. Murphy, does that conclude your business today?
It does. Thank you, Judge.
All right. Best of luck to you, sir. Have a good afternoon. Who do we have next?
36 Strong.
I'm sorry, what number?
36 is Strong.
All right, Ms. Strong, your case is 25 CR 006026J. You're charged with contributing to the delinquency of a minor and simple battery. Do you understand your rights today?
23, got an open burglary, criminal damage to property, second degree. Giving false name, obstruction. It's 25 SC 002280. 2025 suspended license. I got a 2025 battery 24 fade to appear. 2019 fade to appear. 17 fade to appear. And I already said the burglary, so that's it.
All right, thank you, Mr. Sirocco.
Thank you, Your Honor. This incident took place, this was September 11th. This was at 5120 Old National Highway in Atlanta, which is adjacent to the related Skyview High School, located at 5134 Old National Highway. The officer made contact with the victim's mother here, Miss Sharon Jeter. At that location, she had come to school to speak with the police regarding her daughter, who is 16. Miss Jeter's daughter, juvenile LJ, had provided law enforcement video officers with video footage of the incident, which showed the defendant.
Yeah, this one here is out.
Oh, Ms. Bridgewater, please. Go ahead. I'm sorry, Mr. Sirocco.
Oh, no worries, Your Honor. Miss Jeter's daughter had provided law enforcement with video footage of the incident, which showed the defendant, it showed her enticing her 15-year-old daughter, juvenile JS, to fight LJ, her daughter. From the video footage, the defendant can be heard telling her daughter, "You better beat this bitch to death." That escalated the situation, and both juveniles started fighting. And during that fight, the video also showed the defendant squared up with her fists, balled up in a fighting stance toward LJ, Miss Jeter's daughter, and also showed the defendant with her arm wrapped around LJ's head while on the ground. We have spoken with the victim's mother here, Miss Sharon Jeter Lowe. She explained that her daughter and the defendant's daughter had gotten into it verbally during school, had come home, and then on Thursday there was an issue, something regarding an outfit, and there were accusations from the defendant that the the victim was bullying the defendant's daughter. All that was caught on tape. The victim had gotten jumped here, and she states she didn't understand why the defendant just didn't notify the school, which is a fantastic question. After the incident, defendant kept coming up to the school, and the defendant has, since the incident, harassed Miss Jeter online, trying to get her to fight. She stated that Miss Jeter stated that her daughter, the victim here, is scared, and she does not want. She's concerned that once and if the defendant bonds out, for their safety. The defendant has been writing in her direct messages saying she knows where she stays. Miss Jeter's is interested and hopefully in the process of taking out a TPO. Given the history here, I noted, and I believe as pretrial did, 4 FTAs from Clayton. Excuse me, the most recent was in Clayton in 2024, but 4 since 2017. And just as well, there is the risk of reoffense, excuse me, of intimidating the witness here. And we are concerned for the victim and the victim's mother's safety. State's recommendation as such is a $6,000 total surety, $3,000 on each charge. We're recommending 2-day anger awareness, a parenting class, no further contact with Sharon Lowe, no further contact with juvenile LJ. Stay away from Skyview High School at 5134 Old National Highway in Atlanta. Stay away from the victim's residence. wherever she resides, and no drugs, weapons, or alcohol while out on bond. If we could sound for Miss Jeterlow at this time.
All right, is Ms. Jeter present, wish to make a brief statement? So please unmute, turn on your camera. All right, who represents this defendant? Or is this defendant pro se?
This is McLean's case.
Mr. McLean, please proceed.
Okay, I'm sorry, Your Honor, I was just getting another phone call.
Position 36, Ms.
36.
Strong.
Thank you. Let me flip to 36.
Oh, and while he's getting acquainted, Your Honor, I would just reiterate that battery arrest from this year, it looked like it was from January. So want to add that as well.
Okay, what we have here, Your Honor, is that Ms. Strong is a high school graduate and has a College Park address of Valley Bend. So, and she does cosmetology, and she's in Georgia all her life. And I understand the prior arrest number was how many cycles?
Let me see. Mr. Howard, how many arrest cycles there were? There was 20, 25 battery, 20, 24 FTA. I don't have the number of cycles, Mrs. Sirocco or Mr. Howard.
Who is this again?
We're still on strong.
I got 23 total.
Okay, very good. So we would ask the court to set the bond as low as reasonable, Your Honor, as low as possible. If a signature bond is something she's not eligible for in the court's opinion, then we would ask for a $1,000 surety.
All right. Defendant is going to receive a $2,500 surety bond, 2,000 on, I'm sorry, yeah, 2,000 on the simple battery and 500 on the contributing to the delinquency for the total of 2,500. She's to stay away from the Skyview High School and also the residence of the victims, Miss Jeter Lowe and the minor child. She's not to contact them, whether through social media, internet, phone, text. She sees them, she should turn and walk in the other direction. She's to have no alcohol, drugs, or weapons, and she will be reset to all purpose on the 14th. Is there anything additional?
Nothing else, Your Honor. Thank you.
That's all.
All right. Best of luck to you, ma'am. That concludes your case. Who do we have next?
Position 14, Ms. Cousin.
All right, Ms. Cousin. Ms. Cousin, your case is 25 CR 006053D. You're charged with 2 counts of simple battery. You understand your rights? All right, Mr. Howard.
First.
Thank you. All right. Whose case is this for state, Mr. Rose?
Your Honor, I'm sorry, what's this position again? I'm sorry.
14 cousins.
Cousin. Gotcha. Thank you, Judge. Yes, as it relates to Miss Cousin, that is my case. And Your Honor, in this case, Miss Veronica Cousin does not have any history. However, the warrant reads that on September 30th, 2025, Officer Smith Edwards was assigned to an extra job out at the Woodland Heights apartment, 2500 Center Street in Northwest Atlanta. And during her shift, she was approached by the property manager, Mr. Tim McNeely, who basically informed her that he had some footage of a battery and assault of some minor children that were on the property. And so essentially, Mr. McNeely was able to show the officer that video footage, and he was able to recognize that it involved a lady with the nickname of Puddin. Puddin was later identified as Miss Veronica Cousin. He also advised officers that she was a resident at apartment B202. And he also recognized the kids to be residents of apartment B123 in the same apartment complex, not the same apartment as Miss Cousin. So officers did do an investigation. They were able to reach the mother of the two juvenile victims in this case, and the mother's name is a Miss Brianna Harris, and those children's name, one is Coley, spelled Khol apostrophe E Evans, and the other one is Zariah, spelled Zariyah Evans. The children are of age 10 and 8 respectively. So Coley is age 10 and Zariah is age 8. Uh, Officers reviewed the video and first they spoke with the two juvenile children, and juvenile children told them that an incident had taken place at the park that involved Miss Cousin's child, her son, where he initially had assaulted one of those two young ladies. And then when the other one tried to intervene, that's when Miss Cousin came out. She punched one of the two sisters in the chest. And then when the other one went to step up to her, she grabbed her and also punched her in the chest, Your Honor, and basically held her down so that her son could also punch her in the chest. Officers, after getting those statements, also reviewed videos, and the videos corroborated with what the officer was told by the two minor children, again, ages 10 and 8. They did ask the mother of those children if she wanted to press charges. She said that she did, in fact, want to press charges in this particular case. And when they confronted with Miss Cousin with the video, she shrugged her shoulders as if she didn't care, Judge. And so she was arrested. I do understand that she does not have history. However, this did involve two minor children, and it was abuse of those two minor children. So the state is asking for a surety bond in this case, given the defendant's conduct. These children were not her children or not relatives of hers. And I'm asking for a $10,000 surety bond, $5,000 on each child that she assaulted and battered on that particular day. And that she has no further contact with Chloe and Zariah Evans, nor their mother, Brianna Harris, and that she stay away from where they live, and they are at in the same complex but a different apartment B123 at 2500 Center Street in Northwest Atlanta. And that is the state's recommendation. And if Your Honor feels that anger awareness is appropriate here, Your Honor, we would not object to her having to take anger awareness classes. Whereas she should have been trying to break the fight up, she exacerbated the fight, and that is the basis for our judgment. That's the basis for our request, Your Honor, not our judgment. Thank you, Judge.
I know what you meant. Ms. Harris, I see you on the screen. If you'd like to make a very brief statement, please unmute and raise your right hand. You're not required to, but if you wish to, this is your opportunity. You're going to need to back up so we can see you more clearly. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, I do.
All right, you can put your hand down. What would you like to tell me?
I would like to tell you I agree with him on everything that he said. Instead of Miss Cousin breaking it up, she escalated. My kids do have to go walk her way to go to school, and they now is scared to just walk their way. Her being an adult, she shouldn't have put her hands on my kids. And we normally communicate, like we would have normally communicate this out. She didn't come to me. She also told me herself that she put her hands on my kids, and she would do it all over again. I asked Miss Cousin, why did she bring her child back there to fight my baby? She said I was bringing him back there to get his lick back. So everything that he said, I totally agree with that.
All right. Thank you.
It should have been upgraded to
No, please mute whoever that is talking. Absolutely not. Ms. Pinto, please proceed.
Thank you, Judge. Miss Cousin is 52 years old. She's lived in Atlanta her entire life. She has 5 children who are all grown at this point, but she also has custody of 2 of her grandchildren, ages 14 and 9. Most of her family is here in Georgia, so she has strong ties to the community. She went to the 10th grade. She's not currently working. She's waiting on disability benefits to come in. As was noted, she's happy to abide by no further contact or stayaways. They do live in the same complex, so it would just have to be, with that in mind. This is the first time she's ever been arrested. I will note that she denies the allegations as recited by the state, and that she was acting in defense of her grandchild. And in the warrant, it even says that she told police that she was trying to break up the fight and that the other children started it. So I think there, of course, there are at least two sides to this story. But regarding bond, pretrial recommended a signature bond through the jail. We would ask for a signature bond, given her lack of history and her ties to the community.
All right, defendant's gonna receive a $2,500 surety bond, 1,500 on count one, 1,000 on count two. She's to have no contact whatsoever with any of the minor children involved. And Miss Harris, she's to stay away from that incident location. She can return to her own home, of course, but she needs to stay far away from wherever the alleged victims reside. She's to have no alcohol, drugs, or weapons. And because she's receiving a surety bond, she's going to be reset to the October the 14th state all purpose calendar. Is there anything additional?
Nothing additional from the state. Thank you, Your Honor.
All right. Best of luck to you, ma'am. That concludes your case. Who do we have next?
Next is position 13, Mr. Charles.
All right, Mr. Charles, your case is 25 CR 006031Y. You're charged with 2 counts of battery family violence and 2 counts of simple battery family violence. You understand your rights?
14 total. You got an open case out of Gwinnett for shoplifting. 2021 battery DV dismissed. 2020 failed to appear. And he had an 03 violent arrest conviction.
All right, thank you. Whose case is this for the state?
My case, Judge.
Please proceed.
Yes, Your Honor. Just briefly about the facts. This occurred September 29th, 2025. It occurred at State Farm Arena. An officer was flagged down by security employees working at State Farm that advised that they had witnessed a male, in this case, the defendant, assault a female. They pointed to Mr. DeJuan Charles, who committed the assault. The officer tried to investigate the assault, and Mr. Charles made an aggressive motion toward the officer. He ignored commands and became aggressive, which resulted in him being tased and detained. The basis for the batteries is that the security guards witnessed, and the victim in this case, Miss Carol Ayanagu, last name spelled Ayanegue, told that she took the defendant's phone. He became upset. He pushed her to the ground and hit her in the stomach area. She sustained a busted lip and a visibly bruised elbow. The two of them are in a relationship and they do live together at 1658 Cutleaf Creek, Grayson, Georgia, 30017. Given the amount of cycles and the open case, we are asking for a $2,000 secured bond to have no further contact with Miss Carol Ayanagu, to stay away completely from Miss Ayanagu's residence, in that he take a 1-day anger awareness course, Your Honor.
All right, thank you. I'm going to sound for Carol Iwanagu at this time. All right, hearing and seeing none. Mr. McLean, or is this Miss Pinto? Is this your case?
Yes, Judge.
Please proceed, Ms. Pinto.
Thank you. Mr. Charles is 42 years old. He's lived in Atlanta since 1995, so a long time at this point. He has one child that is 4 years old, and he's the single parent to that child, so he's very eager to get out of jail, and return to caring for him. He does have siblings who live here in Georgia. He did some college at Gwinnett Tech. He owns a family business. It's Brianna's personal care home. They provide a home for disabled people. He's worked there for 24 years. So very strong ties to the community. I saw no failures to appear in the last 2 years. I did ask him about the open case on the pretrial report, the theft by shoplifting. And he reports that that was actually his brother. His brother used his information. So I don't think that case should be held against him. Pretrial recommends a signature bond at level 1, and we would ask for the same.
All right. Defendant is going to receive a $1,500 surety bond, $500 on counts 1 and 2, and $250 on each of the remaining counts to get us to that $1,500. He's to have no contact with the alleged victim and stay away from that location as well as the victim's address. He's to have no alcohol, drugs, or weapons, and he'll be reset to October the 14th. Is there anything additional? All right, hearing none. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Number 45, Woodford.
All right. Good afternoon. Your case is 25 CR 006027D. You're charged with criminal trespass and damage to property and disorderly conduct. Do you understand your rights today? All right, Mr. Howard.
9 adult on probation out of car for battery DV. 2025 probation. 24 failure to appear. 21 failure to appear. 2020 battery DV conviction. Um, 2020 trespass giving false name conviction. 2019 trespass conviction. That's it.
Okay, thank you. Mrs. Sirocco.
Thank you, Your Honor. This incident took place September 29th of this year. This is at 46001 Roswell Road in Sandy Springs. It's the Chastain Apartments there. Law enforcement responded to a call at the complex, and the officer, upon arrival at the apartment, heard the defendant yelling at her girlfriend, Miss Natalie Scales, through the door. Officer heard her call Miss Scales a weird ASSBITCH multiple times, yelling that, heard yelling at Miss Scales, and the Miss Scales' daughter was crying, and it's a 4-year-old, I believe. Defendant was also heard by the officer telling Miss Scales that she would throw her cell phone and break it. Officer made contact with the victim here, Miss Scales, who stated she and the defendant are in a relationship, and they have been living together for the past several months. There was an argument, a disagreement over putting away groceries, and it was thought by the defendant that Miss Scales had slammed a box during the argument. And it was at that point the defendant became enraged, took a TV remote and threw it at the television, damaging the screen. We have spoken with Miss Scales here. She expressed that the two of them did go grocery shopping. She had walked outside and to give the defendant some privacy. There was some call that came into her, and there's an issue with there's an issue with who was calling the defendant at the time, and I think that sort of escalated here. Ultimately, they started arguing, confirmed that she did take the remote and threw it at the TV. The officer came by and helped de-escalate the altercation. She expressed that she did not want the defendant to go to jail. The police, she says, have been called before. The last time was August 3rd, when the victim called the police because she had lent her car to the defendant, supposed to pick her up at 7:30, and ultimately she had gotten locked out of the house. That being the victim, they had to call a locksmith. It didn't appear to be a violent incident, I'll say that. And the two have been together since this year. They've known each other for years, however, and she wants the defendant to work on herself and presumably her anger issues here. The TV was hers, the damage done to it, it would be $200 worth. But the defendant has told her that she will replace it. She's fine with no further violent contact. The state, however, is not, given the battery family violence conviction from Cobb, convicted 2021, recidivist battery family violence conviction 2024, also her FTAs from 2021 and 2024. We would have concern about escalating violence here, and we don't think they should be around each other. With her to history, it's a recipe for disaster here. So we are, out of an abundance of caution, going to recommend no further contact, as well as a stay away from 46001 Roswell Road in Sandy Springs, that Chastain's apartment address. In total, the state would be recommending a $4,000 total surety on account of her history, violent history, and failures to appear. As well, we'd be asking for 2-day anger awareness and no drugs, weapons, or alcohol while out on bond. I believe I saw Ms. Scales on. If we could sound for her, that is all for the state.
All right, Ms. Scales, if you wish to make a brief statement, turn on your camera, raise your right hand.
Yes, Your Honor. It's disabled for some reason. It says the host disabled it.
Probably because you were standing up moving around. They should be able to do it now.
Yes,
Please
Your Honor.
raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right, briefly, what would you like to tell me?
Yes, ma'am. I would like her to come home. We have her child's birthday this weekend. It's her 2-year-old birthday. I don't have kids. It was her child that was crying. I don't have kids. I have a very strong connection with her family. I do not feel threatened. I do not feel in danger. We are working very hard together to get stuff right. I'm a nurse. She's not a threat. She's a wonderful person to me, and she's a wonderful girlfriend. I don't feel threatened at all.
All right, thank you. I appreciate you
welcome.
coming to court to make that statement.
Thank you.
Who represents, Mr. McLean, please proceed.
Yes, Your Honor, we would ask the court under these circumstances to consider a signature bond, just from the overall circumstances. She does warehouse work and is a high school graduate, age 24. Thank you.
All right, defendant's gonna receive a $2,000 surety bond, $1,500 on count 1, $500 on count 2. She said have no further violent contact with Ms. Scales, have no alcohol, drugs, or weapons. Is there anything additional from state or defense?
Nothing.
Nothing to say, Your Honor.
All right, best of luck to you, ma'am. That concludes your case at this time. Who do we have next?
Position 15, Mr. Cox.
Mr. Cox, your case is 25 CR 006029G. In this case, you're charged with battery family violence, 2 counts of simple battery family violence, and 1 count of obstruction. Do you understand your rights?
Yes, Your Honor.
Thank you.
5, 2014 DUI arrest. Before that was 2000 battery DV conviction.
All right, thank you. Whose case is this?
Mine, Your Honor.
All right, please proceed.
Yes, Your Honor. It is alleged that on September 11th, 2025, the law enforcement officers made contact with the victim in this case, Miss Ayaris Cox, Ayaris Cox, who is the wife of the defendant. She informed officers that While in bed, Mr. Cox mounted on top of her and struck her multiple times in the head and face. She does allege that he choked her. She also said that she had to wiggle out from underneath him, and she locked herself in the bedroom closet. The officers were able, when they were able to speak with her, they witnessed or saw multiple red marks on the victim's head and face. As far as the obstruction, the officers made multiple commands for him to exit the bedroom with his hands up, which he did not comply. They made entry into the bedroom and witnessed the Mr. Cox flopping around naked in the bathtub with water running. The officer struggled to remove him from the bathtub. Once he was removed, he was commanded to put his hands behind his back, and he still did not follow directions. In this case, Mrs. Cox, she does state that he has he has some mental health diagnoses. He's been diagnosed with depression and ADHD, and he is also recovering from alcoholism, and he's been self-medicating with alcohol. She does fear for her safety. She is still seeking medical treatment from the injuries. With that being said, we were going to request no further contact at all with Mrs. Cox, that he undergo an alcohol drug evaluation and treatment, that he consume no alcohol or drugs and have no weapons while out on bond, that he undergo a mental health evaluation and treatment. And given the severity of the allegations, including the choking, we are going to request a $2,000 security bond, and that he stay away from, again, Mrs. Cox, but also her address.
All right, is Ms. Cox present? If you wish to make a very brief statement, please unmute and raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, what would you like to tell me?
Simple. I simply want to feel safe and protected. I want to make sure that he's not near me or my place of residence, evidently. And I would like for him to cooperate with the divorce. I know it's silly. Also, having said all that, I really, truly just want him to get the help he needs. I think he requires help to rebuild his life. I really, truly want him to do better, to take things seriously, to know that he has to be better for our daughter and his family that loves him very much, and they're trying the best to help him out. And finally, I really, truly do not wish him any harm. I don't want anything bad to happen to him, but he needs to take this seriously. That's all.
All right, thank you, ma'am. I appreciate you coming to court and making that statement. Mr. McLean?
Mr. Cox is 49. He has had some college, and he has stated to me that he's a homemaker and has done that for quite some time. We would ask the court under these circumstances to consider a signature bond with appropriate conditions.
All right. Defendant is going to, hold on, let me do my math. Hold on. Is it there's 4 counts, correct?
Yes.
Okay. All right, defendant is going to receive a $2,500 surety bond. He's to have no contact with the alleged victim, last name Cox in this case, and stay away from that location. He can return one time with a member of law enforcement should he need to get any items. He additionally is to have no alcohol, drugs, or weapons. And because he's getting a surety bond, he will be reset to the state all-purpose calendar on October the 14th. Is there anything additional?
Nothing.
All right, sir.
You want to break that down for me, please?
I'm sorry, 1,000, count 1, 500 on each remaining count.
Thank you.
All right, best of luck to you, sir. Who do we have next?
Position 37, Mr. Terry.
Mr. Terry, your case is 25 CR 006030E. You're charged with terroristic threats and acts and disorderly conduct. You understand your rights?
Yes.
All right, Mr. Howard.
2024 ag assault dismissed. 2018 suspended license dismissed, and 2009 petty theft conviction.
Okay, thank you. Mrs. Sarafa?
Yes, Your Honor, this incident took place. This was August 9th of this year at 943 Boulevard, Southeast in Atlanta. Officer made contact with the victim. This was the day after Mr. James Miller, as well as the homeowner of that location, Stephen Dalton. They came to the police precinct to file a report regarding intimidation and threats made by the defendant. Mr. Dalton stated that the defendant, who's been living in his home, which he rents out for the past 4 years, um, the, excuse me, yeah, the that individual, Mr. Dalton, had witnessed the defendant state James may be looking for a fight, but he will be offed, and that was regarding Mr. Miller, and also stated that there are issues, according to Mr. Miller, with respect to the defendant going through his belongings, allegations which Mr. Miller denies. He reported that he avoids the defendant at all costs due to the defendant's confrontational behavior. Mr. Dalton also stated that he witnessed the defendant make threats, including saying there's going to be a murder in this house while carrying a large knife and referring to Mr. Miller. Mr. Dalton expressed fear of the defendant, but explained that due to his age and ongoing health issues, he's been unable to evict him. Mr. Miller provided photos showing the defendant standing in the doorway holding a large kitchen knife in an intimidating manner. These have subsequently been sent to us, and I have seen them myself. It is intimidating. We have spoken with the victim here, Mr. Miller. He stated that he confirmed the defendant moved in around 4 years ago. Everything there is in the Mr. Dalton's name. And the defendant and the victim have always had issues. Defendant has previously pulled a butcher knife on him twice. He stated that the defendant drinks a lot, and that he feels endangered. He's in the process of filing for a TPO. He actually came into our office yesterday and reported that the defendant has been making threatening phone calls from the jail, and that the defendant previously forced his way back into the residence after being put out by Mr. Dalton. He expressed he does not feel safe in the home while the defendant remains involved. Even while the defendant's in custody, he feels fear. He further reported that during a previous altercation, he was threatened with a large kitchen knife and stated the defendant stated that someone is going to get murdered today. He has call records and other evidence that he is going to provide us with respect to that. He strongly requested this case be transferred to the DA's office, which the state is in the process of waiting for an answer on. We have sent this to the DA's office, and we look forward to their response on that. That aggravated assault, I do want to add, from 2024, that arrest, that was for spraying a different roommate in the face with bear mace, though the case was ultimately dismissed. It does speak to the defendant's issues with roommates and propensity towards violence. We are concerned for this victim's safety. The defendant does pose a threat to Mr. Miller, at risk of witness intimidation to Mr. Dalton as well, who's also in fear, and also the victim here. So the state's recommendation is going to be a $5,000 cash bond on this, $3,000 on the terroristic threats and acts, $2,000 on the disorderly conduct, 5 days anger awareness, no further contact with James Miller, no further contact with Stephen Dalton. Stay away from 943 Boulevard, Southeast Atlanta. No drugs, alcohol, and no weapons of any kind while out on bond. We would also, given what Mr. Miller told us, be asking for random screens for drugs and alcohol. That is all for the state. If we could sound for Mr. Miller at this time.
All right, is Mr. Miller present, wishes to make a very brief statement? If so, please unmute, raise your right hand. That's Mr. Miller. Mr. Miller, you need to unmute and come into the view. We can only see your hand. We can't see you, and you need to unmute. Please figure it out quickly. All right, please raise your right hand. Do you swear or affirm the testimony you give today be true to the best of your knowledge?
Yes.
All right, what would you like to tell me?
It's been a lot to deal with, honestly. I can't even really verbalize right now. It's really been a lot. From being accused of things that I haven't done to having weapons pulled on me for whatever reason. I don't know. I can't make sense of that. To me trying to stay out of the way, to not be involved in conflict and being involved in it anyway. It's been a lot on me mentally. Emotionally, of course, yes, but it's been a lot to deal
So
with.
it's safe to assume you wish to have no contact with the defendant?
None at all.
Okay. Is there anything else you'd like to tell me briefly, Mr. Miller? There will be other proceedings, and this is just a bond hearing today. I don't want you to feel as if I'm cutting you off unnecessarily, but there will be other proceedings where you can flesh out the case, the facts of the case, okay? So is there anything else besides the no contact you want the court to be aware of?
Not that I can think of right now, no.
All right. I do appreciate you coming to court and making that statement. I know that may have been difficult for you. All right. Thank you.
Thank you for being here.
All right, Mr. McLean.
Your Honor, Mr. Terry's 34 years old, and his career has been in restaurant work as a cook. Back of the house is the expression, as they use it, but he's done various things in the dishwashing area, and then also graduated to cook. He's done that for years. We would ask the court to consider a signature bond if that's possible. And if it's not, then a $1,000 bond. He will obey the court's orders, he tells me, on whatever conditions are necessary.
All right. Defendant is going to receive a $3,000 surety bond, $2,500 on count 1, $500 on count 2. He's to have no contact with either of the alleged victims' names in this case. Last name Miller and last name, is it Dalton? He's to have no weapons, including the subject weapon of this case, no alcohol, no drugs. He'll be reset to the all-purpose calendar on October the 14th. And also he is to stay away from that location if I didn't already say that. Is there anything additional from the state or the defense?
Nothing from the state, Your Honor.
Nothing. Thank you.
All right. Best of luck to you, Mr. Terry. That concludes your case for today. Who do we have next?
Position 22, Mr. Hemi.
Okay. I didn't.
All right, sir, your case is 25 CR 006033C. You are charged with simple battery family violence. Do you understand your rights today? All right, Mr. Howard. Oh, first arrest, so we'll go to Mr. Sirocco.
Thank you, Your Honor. This incident took place, this was September 29th at 1280 Atherton Park in Roswell. Law enforcement responded to the location, made contact with the victim, Miss Cheryl Chineme, who explained that the defendant held her down and threatened to beat her. The warrant is fairly limited with respect to further information, but we do know that the two lived together at the incident location. We have not yet spoken with Ms. Chineme, but we would ask the court sound for her when appropriate. State's recommendation here, given this being first arrest, is signature bond through pretrial. We are recommending FIB. No further contact with Ms. Chineme. Stay away from 1280 Atherton Park in Roswell. And no drugs, weapons, or alcohol while out on bond. That is all for the state.
All right, I'm sorry, the name of the victim again?
It's Cheryl, traditional spelling, and then Chineme, Chineme.
All right, is that party present and wishes to make a statement? Hearing none, Ms. Pinto.
Thank you, Judge. Mr. Heme is 44 years old. He's lived in Atlanta for 12 years. He has two children, ages 3 months and 3 years old. His fiance, significant other, kids, and brother all live in Georgia as well. He did graduate high school. He is self-employed. He does music production, and he also works for a collections agency. He's been doing the music since 1998 and the collections for 2 years now. I did speak with the alleged victim in the case. She was going to log on, but she may have had to leave. She told me that they do not live together. It's my understanding that she moved out of that incident location the day that Mr. Iheme was arrested. She's not interested in contact, but they do share children. So just contact regarding the children. As noted, this is his first arrest. We are asking for a signature bond.
All right. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. He's to have no contact with the alleged victim and stay away from that location. He can return one time with a member of law enforcement to get any items. He's going to take the 1-day anger awareness course and will be reset further notice. Is there anything additional from the state of defense?
If the victim doesn't live at that incident location, can he return to that incident location?
He can make that determination with a member of law enforcement. If she's still there, he'll need to stay away.
Okay.
All right. Best of luck to you, sir. That concludes your case.
Thank you. Takes us position 26, Mr. Mateen.
Mr. Mateen, your case is 25 CR 0060378H. You're charged with 3 counts of simple battery family violence. Do you understand your rights? All right. I have that this is first arrest, so we'll go to Mr. Saraka.
Could I confirm very quickly, Judge, what is this case? Which case number is this?
26.
26, and that is okay, thank you. All right. I have that right here. Yes, Your Honor. This incident was from September 29th. This was at 85 Mount Zion Road in Atlanta. That's an apartment complex. Officers were actually flagged down by a third-party witness who observed a male physically restraining a female, slamming her to the ground and dragging her against her will. The officer made contact with the defendant, and the defendant stated that his daughter, the victim here, Miss Aya Mateen, had been disrespectful to him and his wife, and he wanted to speak with her outside the home. So he grabbed her by the arms and attempted to pull her outside the apartment. Miss Mateen stated that her father, when officers spoke with her, grabbed her by both arms, began dragging her toward the front door, and she went limp. The defendant was arrested there. We have spoken with the victim in this case. She stated that she confirmed the defendant is her father. She wants to drop the charges. We will be proceeding with the charges as they are the state's. The police were contacted as a means of de-escalation, she says, but I'm not sure how that can be true with a third party calling this in. Her parents, she states, have been controlling, and due to her age, she's reluctant to move on their time. She was asked to clean up, and there were other issues that came up. She became agitated, she states, and things escalated. She refused to leave when the defendant demanded that she do so, and it was at that point he attempted to forcibly remove her from the residence, at which point she dropped dead weight on her father. She went limp, and ultimately, the state's recommendation here is, given the lack of history, a signature bond through pretrial services. We are recommending 2 days anger awareness, no further violent contact with Aya Mateen, and no drugs, weapons, or alcohol while out on bond. If we could sound for Miss Mateen at this time.
All right. Is Ms. Mateen present and wishes to make a very brief statement? All right, Mr. McLean.
No objection, Your Honor.
All right, defendant is going to receive a $3,000 SOB through pretrial services. $1,000 on each count. He's to have no further violent contact with the alleged victim in this case. Take the 1-day anger awareness course and have no alcohol, drugs, or weapons. He will be reset to the, he actually will be reset for the notice because he got a signature bond. Is there anything further?
Nothing from the state, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Next is position 29, Mr. Rogers.
All right, good afternoon, Mr. Rogers. Your case is 25 CR 006028 F. You are charged with theft by taking. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
2018 driving without a valid license. 2010 theft by receiving. 2010 battery DV. That's it.
Thank you. And Ms. McGill, please proceed.
Yes, Your Honor. This incident occurred April 9th, 2025 at 813 Liberty Commons Drive, Atlanta, Georgia. The law enforcement made contact with the victim in this case, LaSherry Hudson, first name LA''SHARIERE. She informed the officers that the defendant threw her phone in the woods, and then he went to go get it, and he would not give it back. Given his history of theft and one being recent, a recent arrest from excuse me, just given his history of theft, we are asking for a $1,000 secured bond and to have no further contact with Miss Hudson or the 813 Liberty Commons Drive address in Atlanta, Georgia.
Okay, so he threw a phone in the woods allegedly?
Yes.
Is Miss Hudson present, wishes to make a brief statement? And Mr. Howard, that was 2010 theft by receiving?
Yeah.
Okay. Mr. McLean?
Your Honor, he is 51 years old, went through the 11th grade in high school, so substantially completed high school. He's worked in a retail store and does maintenance. Because of this is from April of this year, because it is from April, I emphasize that and ask the court to consider in this situation a signature bond, given also the age of the theft by receiving from 2010. Thank you.
All right, defendant is going to receive a $5 cash bond. He's to have no contact with Miss Hudson, stay away from Liberty Commons, and have no alcohol, drugs, or weapons because he's getting the cash bond. He is going to be reset to the all-purpose calendar on the 14th. Is there anything additional?
Nothing.
All right, what do we have next?
Next is position 9, Mr. Browning.
All right, Mr. Browning, your case is 25 CR 006063B. In this case, you're charged with criminal trespass. You understand your rights? Is that a yes? All right, thank you, Mr. Howard.
You got an open DUI, expired tag, attempting to misrepresent tag, possession of open container. He has a bench warrant on a 2025 act, stop and arrest.
Okay. Ms. McGill, please proceed.
Yes, Your Honor. This incident occurred September 22nd of this year. Law enforcement officer responded to the incident location 1100 Welch Street Southwest in reference to an unwanted male at the location. They were informed by James Sanders and Monique Johnson, who both lived there, that Miss Johnson's ex-boyfriend, the defendant before you, was sitting in the driveway in her car. She had called police officers out there earlier in the day, and they made him leave. He returned, and he proceeded to throw large rocks at the house. They did inform him to leave again, and he refused. And so that's the basis for the criminal trespass before you. The state is concerned about his open pending aggravated stalking, and the fact that he seemed to brazenly go back to the incident location after he was told to leave. So with that being said, we are going to first recommend a complete stay away from both Miss Monique Johnson and Mr. James Sanders, a stay away from 1100 Welch Street Southwest, Atlanta, Georgia, and a $2,000 secured bond, Your Honor.
All right. Are either Ms. Johnson or Mr. Sanders present and wish to make a brief statement? Hearing and seeing none. Ms. Pensel?
Thank you, Judge. Mr. Browning is 39 years old. He's lived in Atlanta for 37 years. He has one child that's 12 years old. He also has his sister and his father who live in Georgia. He did attend some college. He has a good job working at Peachford Hospital as a mental health technician. I will note that the aggravated stalking arrest, that case was dismissed in January of this year. So I certainly don't think that should be held against him. He did unfortunately have a failure to appear because he had to move after finally receiving a signature bond on his previous case. He had been in jail for 3 months, lost everything, had to move, and unfortunately didn't get the notice. So he does already have a $3,800 bond on that failure to appear. For this case, pretrial recommended a signature bond at level 1. He's not able to pay anything, so we are also asking for a signature bond.
All right. Defendant is going to receive $1,000 surety bond. He needs to have no contact with either of those alleged victims, stay away from that location, and have no alcohol, drugs, or weapons. Is there anything additional from the state or defense?
No, Judge.
All right. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Position 12, Mr. Carter.
All right, good afternoon, Mr. Carter. Your case is 25 CR 006051E. You're charged with hit and run and driving while your license is suspended or revoked. Do you understand your rights?
Yes, Your Honor.
Thank you. Mr. Howard?
14. Yeah, the open case out of Hancock County. Prohibited item by inmate. Possession of tools. Use of communication facility in the commission of a felony. Open case out of Screven County. Identity fraud. 2022 suspended license no low. 2012 suspended license no low. 2012 robbery conviction.
All right, thank you. Mr. Rhodes?
Yes, Your Honor. Very briefly, this stemmed from August 22nd of 25. It was a 3-car accident. The Mr. Carter was hit from behind, and it caused him to hit somebody from behind. So he wasn't the person that started the initial accident, but he did hit the third person. Well, they were all waiting for the police to come, and he was on the cell phone. He gradually went towards the woods and gradually kept going and disappeared into the woods and never to come back. And so essentially he abandoned the car there. His girlfriend did have to come pick it up. they were able to give the officer, she was able to give the officers his name, and they were able to confirm who he was on GCIC. That does form the basis for the hit and run. Obviously, uh, from what we know of civil law, the transaction that he hit the third car may be something you have to litigate. But as such, he does have an open case, Your Honor. It was a accident that he should not have fled from. And I do believe this criminal history is as such that I'm asking for a good bond in the amount of $3,000, 1,500 on each of the charges. And because we know that his license is suspended, that he does not drive without a valid license. So 3,000, Judge.
All right, thank you, Mr. Rhodes. Ms. Pinto?
Thank you, Judge. Mr. Carter's 35 years old. He's spent his entire life in Georgia. He has 3 children, ages 17, 14, and 7. And his whole family is here in Georgia. He did do some college at East Georgia State. He has a good job working for Home Depot doing appliance installation. He's been there almost a year. I will note that he reports that the Screven County case that is set to be open was actually dismissed. Pretrial recommended a signature bond at level 3. We would ask for a signature bond or a bond not to exceed 1,500 total.
All right. Defendant is going to receive a $1,500 surety bond, 1,000 on count 1, 500 on count 2. He's not to drive unless he has a valid license issued by the state of Georgia or other state Department of Driver Services. He's to have no alcohol, drugs, or weapons, and he's going to SAP on the 14th. Is there anything additional from the state of defense?
Nothing.
I have 3 counts, Judge.
It's 2, hit and run and that duty to drive. They separate it, but it's really 1 charge. If you look at the offense date, there's only 2.
Okay, got it. Thank you.
All right. Best of luck to you, sir. Who do we have next?
Next is position 7, Mr. Brown.
And after Mr. Brown, we're going to take a very brief 2-minute break. Okay. This is Mr. Joseph Brown. All right, Mr. Brown, your case is 25 CR 006040C. You're charged with battery. Do you understand your rights?
No.
Mr. Howard?
6. He got an open battery. 25 CR 006040C. That's it.
Okay. Thank you, Mr. Rhodes.
Yes, Your Honor, on May 27th of this year, so this does date back to May 27th of this year. Officers did respond to 2210 Sullivan Road in College Park in reference to a person injured. When they got there, they spoke with Ms. Shatika Forrest, who stated that her ex-boyfriend began beating on her when he found out that she was with someone else. When officers came, they observed that her nose, there was bleeding coming from her nose in particular. And they did indicate that the nose was broken, so EMT did have to treat, and she had to be transported. Your Honor, in addition to the cycles in Georgia, there was also an arrest out of North Carolina, and he does have the open case of battery. We are asking in light of that for a $2,000 surety bond and that he stay away from 2210 Sullivan Road in College Park, 30349, and had no further contact with Shatika Forrest, and that's spelled Shatika, and no drugs, alcohol, or weapons while on bond. And that's the state's recommendation. Thank you.
The last name was Ford, is that correct?
That is correct. With
All
2
right,
officers.
all right, I see you on the screen, ma'am. If you'd like to make a statement, please raise your right hand and unmute. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
All our things we had together, it don't be nothing physical. It just be verbal. So with him having to get arrested the other day, it was just over a verbal argument. It don't be anything physical. And I do want him to still reside in my home, and I still want to interact with him. So.
All right.
I appreciate you coming to court and making that statement. All right, Miss Pinto.
Thank you, Judge. Mr. Brown's 24 years old. He's lived in Atlanta his entire life. He has two children, ages 7 and 4. He also has his siblings, cousin, and that live in Georgia. He went to the 11th grade. He has a good job working overnights at UPS. He's been there since June. We are asking that he be allowed to have contact with the victim, which I understand is also what she wants. I don't see an open battery in Odyssey, so I'm not sure what that case was, but he's not able to pay any bond, so we would ask the court for a signature bond.
That's this case. I just looked at that too. That's what they had on the PSA for some reason.
Okay, so to be clear, there's no other battery. It's just this case that is
Your Honor,
alleged.
I concur that there's no other battery. I would still say, though, given the gravity of the assault here, that at this time there'd be a cool down period. And I do know, well, this did happen in May. But a broken nose, Your Honor, I ask that he stay away and have no further contact with her.
Dude, can I say something?
You've already spoken, Ms. Ward. We've heard from you. Thank you.
Okay,
All
but
right.
my nose was broken.
No, okay. Thank you. The defendant is going to receive a $2,000 surety bond. He's to have no contact with the alleged victim. Stay away from that location. If he needs to get anything, he can return with one time with a member of law enforcement. He's to have no alcohol, drugs, or weapons, and he's going to the all-purpose calendar on October the 14th. Is there anything additional from the state or the defense?
Nothing from the defense, just the state, Your Honor.
All right. Best of luck to you, sir. That concludes your case for today. We're going to take a very quick 2-minute break. We'll be right back. Thank you. All right. Thank you for your patience. I was having some technical issues. We can continue. Who do we have next? No one's back.
Yeah, we're back, Your Honor. We can go at position number 24, Mr. Jones.
And can we turn on the camera too? Position 24?
Yes.
All right, thank you. Mr. Jones, that's 24 is Jones?
Yes.
All right, your case is 25 CR 006050G. You're charged with 3 counts of battery family violence and 2 counts of simple. Do you understand your rights today? Simple battery family violence. Do you understand your rights?
Yes, ma'am.
Thank you. Mr. Howard?
Okay, Mr. Sirocco, we'll defer to you. Do you have the history?
Yeah, sure. I don't have the total cycles in front of me, but I do have the highlights here. FTAs from 2018 and 2023, that 2023 being a felony FTA out of Henry County. There are arrests for I'll just say battery from 2023. I won't describe the type. Also, another battery case from 2023 where he was arrested for beating a Mrs. Evans Smith, the defendant's girlfriend. So it was also intimate partner slash former intimate partner violence, as the case here, which I'll get into. That was ultimately null prost after the defendant completed pretrial diversion, 8 weeks anger management. Uh, Evidently did not learn from that there. I see a 2025 DUI conviction, and I also see a 2019 disorderly conduct conviction where originally there were charges of battery family violence and simple battery family violence that were ultimately null prost. Reasons why, I'm not sure. That was a DeCat case. This incident here took place June 12th, 2025 at 6622 Maple Lane, Southwest in Atlanta. Law enforcement was dispatched there in reference to a woman injured, and upon arrival made contact with the victim here, Miss Brittany Johnson, who explained that the defendant, the father of her child, with whom they've been together for roughly 10 years and they're no longer in a relationship now, he had come over and was upset with the way she was living and got into an argument with her. He then pushed her and then pushed her down the stairs. I will note that that is a 17-step flight of stairs. Excuse me, and it was also, she also explained that the defendant struck her as well. From these actions, she sustained swelling and dried blood around her nose. It was a busted nose, bruising under her left eye, and busted lip as well, bleeding there. They do not currently live together, and she identified him at the scene. She expressed to us when we spoke with her that she's no longer in a relationship with him. This occurred during a drop-off, presumably with their child, and stated that although she's been with the defendant for 10 years, or had been, it's been on and off due to his to mental instability, excuse me. She has not had issues with the defendant since this incident, and states that she doesn't see him often. Reiterate, they do have that child, and she states that she has no fear of the defendant at this time. She's decided to move on from the relationship, and she would be fine with no further violent contacts to make it easier to co-parent. The state's not comfortable with no further violent contact. We will be asking for no further contact on account of the severity of this incident. This is a brutal attack here, and she was very badly injured from the sound of it. Also on account of his other case, from which he did not learn, which was intimate partner as well. There is a risk of reoffense. We are concerned for the victim's safety here, and we don't want this happening again. The state's recommendation is an $8,000 surety, $2,000 for each battery family violence, $1,000 for each simple battery family violence. And we're recommending FIB as well. No further contact with Brittany Johnson. Stay away from 622 Maple Lane in Southwest in Atlanta, and no drugs, weapons, or alcohol while out on bond. That is all for the state. If we could sound for Ms. Johnson at this time.
All right, is Ms. Johnson present? Wishes to make a brief statement? Hearing none, Mr. McLean.
Your Honor, 30-year-old Mr. Jones has 2 years of college for his education. He has worked multiple jobs, sometimes at the same time, in the last 5 years, 2 different warehouses, demolition work, remodeling work, and has a clothing line as well. He's very industrious. He lives in McDonough, so there is no problem with staying away whatsoever. No problem at all. He asked the court to set the bond as low as possible. If that's a signature bond, excellent. But if not a signature bond, he would ask the court to consider a $1,000 to $1,500 surety.
All right. Give me one moment. Okay, let me be clear. There are six counts. 1, 2, 3.
5, Your Honor.
It's 5.
Mm-hmm.
Okay, so defendant's going to receive a $2,500 surety bond, $500 on each count. He's to have no contact with Ms. Johnson. Stay away from that location. He's also to have no alcohol, drugs, or weapons, and he will be reset to all purpose on October the 14th. Is there anything additional?
Nothing, Your Honor.
Nothing. Thank
All
you.
right, best of luck to you, sir. That concludes your case for today. Who do we have next?
We'll go with position number 40, Mr. Vincent.
State gonna get that history.
What's the position? 40?
40, Mr. Vincent. Mr. Vincent, your case is 25 CR 006056A, in which you're charged with criminal trespass. You understand your rights today? Is that a yes?
Yes.
Thank you. I'm sorry, Mrs. Rocco's gone, so I'm assuming that's not your case?
It is not my case, Your Honor.
It's mine, Your Honor.
All right.
ASG McGill has it.
McGill.
So as far as the history, what I could see is 3 total cycles, including this one. Arrested in November 13th, 2024 for possession of controlled substance and drug-related objects. And it does look like he has, I note that was not a conviction though, but it looks like he has an open case for a criminal trespass from February 27th of this year.
Is it the same location?
It's that I cannot see, Your Honor.
Okay, that's okay. All right, please proceed, Ms. McGill.
So a brief facts about this. The incident occurred on September 30th of this year. It was located, an officer was working at the 2050 Cheshire Bridge Road in Atlanta, Georgia, and noticed that the defendant was on the property after being verbally criminally trespassed twice. The officer spoke to the leasing manager, who confirmed that the defendant was in fact trespassed from the location back in July. After the defendant was Mirandized, he admitted that he remembered being criminally trespassed and that he understood that he was not allowed to be back there. We're asking for no further contact and a complete stay away from the incident location, that he consult a social worker for housing, and we're asking for a 1,000 signature bond on this, Your Honor.
What is 2050 Cheshire Bridge? Is it a gas station? That's what I'm trying to.
It's not a gas station. It's what I can see. Maybe an apartment
building. Okay. All right, Mr. McLean.
No objection to the signature bond idea, Your Honor. He lives quite some distance away from it, on the other side, way on the other side of Brookwood Station over in Northwest Atlanta. So, no objection.
All right, defendant's going to receive a $1 cash bond. He is to stay away from that location, have no alcohol, drugs, or weapons, and again, he'll be reset to the October 14th state all purpose. I am going to ask the social worker come and visit him. Is there anything additional? Yes, sir, you have a question?
I can answer that. If he'll just use the desk phone and speak speak low so as not to disrupt court, he can call me at 5215, my desk extension. That's just 22-5215.
All right, can we let Mr. Vincent give Mr. McLean a call?
Next, we'll go with position number 31, Mr. Shepherd.
All right, good afternoon, Mr. Shepherd. Your case is 25 CR 006039J. You're charged with hit and run and following too closely. Do you understand your rights today? Is that a yes? I'm assuming that's a yes, Mr. Howard.
2019 probation, 2012 failure to appear, 2011 possession of cocaine. That's it.
Okay, Mr. Sirocco.
Thank you, Your Honor. I also have that there was a NOLO within his driving history for failure to obey a stop sign, and also from that same year, this being 2019, driving while license withdrawn. This was an incident that took place September 21st. It was at Glenwood and Winthrop Drive, Southeast Atlanta, and law enforcement was dispatched to a hit and run. Collision involving two vehicles and made contact with the victim, Miss Regina Jones. She was stopped at the red light at the intersection, heading eastbound in the right lane, when she was rear-ended by the defendant. She exited her vehicle, trying to speak with the defendant, at which point the defendant began to back up, turned left, turned into the left-hand lane and fled the scene of the accident. She got a good look at him. The officer was able to make contact with the owner of the vehicle, who said he was not involved in a collision. It was Mr. Ronaldo Shepard. And he stated that his brother, Randy Shepard, the defendant here, is the only one other person that he lets drive his vehicle. There was a photo lineup conducted, and the victim did identify the defendant as the one who collided with her vehicle and fled without checking on her or exchanging information. The state's recommendation here, given the defendant's driving history, is a $1,000 total surety, $500 on each charge here. No driving without a valid license, registration, all the required documentation, and no drugs, weapons, or alcohol while out on bond.
All right, Mr. McLean.
Your Honor, I believe it happened not this past September 21, but
that's correct.
Right. See, it's a year old. So he's 63 years old, lives in Stone Mountain, mailing address near Redan Road. He's a self-employed contractor for the last 24 years in construction, does housing slabs and driveways. He also has a pension that he helps him live off of pension a bit. Walker High School, so he's a high school graduate. We would ask the court to consider a signature bond in this situation.
All right, defendant's going to receive a $10 cash fine, $5 on each count. He is to not drive unless he has a valid license issued by a state Department of Driver Services. He's to have no alcohol, drugs, or weapons, and he will be reset to the all-purpose calendar on the 14th. Is there anything additional?
Apologies, Your Honor. I did. They did mention the FTA. Right. Thank you.
How much was that?
$10, $5 on each count. Sir, you have a question? Very briefly, don't say anything that may incriminate you. It may be better for you to give Mr. McLean a call. What is your question?
I'll give him a call.
Okay, that sounds wise. Take care.
Your Honor, are there 3 charges or?
It's 2. Their calendar prints it that way, but the hit and run and duty to driver is one charge.
Okay, so it's $5.
So he got $5 on each count.
All right, you're fine. All right, next we'll go with position number 44, Mr. Wilson.
All right, are there any announcements from the jail while we're transitioning regarding who will not be brought today?
I'm
sorry, go ahead.
Well, we have waiver cases, position 17, 28, 30, and 42. They waive.
Okay, but there's nobody reset medical or anything like that.
Yeah, we reset. We have position number 3. Hold on 1 second. Give me 1 second. I'm reading somebody else's handwriting. Hold on.
All right, we'll forge ahead with Mr. Wilson while we wait for that. Mr. Wilson, your case is 25 CR 006065D. You're charged with simple battery and criminal trespass and damage. Do you understand your rights today?
No.
All right, thank you. Mr. Howard?
7. 2025 obstruction, possession of marijuana, interference with government property. 2012 trespass, death by taking conviction. 2009 failure to appear.
All right, thank you. Ms. McGill?
Yes, Your Honor. This incident occurred on April 30th of 2024. Law enforcement officer responded to a call from 1322 Redford Drive, Southeast Atlanta, Georgia. They spoke to the victim, Miss Cynthia Walker, who advised that the father of her 4 kids, the defendant before you, was upset with her about taking the kids on a trip, and he pushed her to the floor and kicked the front door open with enough force to put a hole in the wall. Given it does appear, I don't know if I heard pretrial correctly, but it does appear that he has an open case for from April 19th of last year for obstruction of law enforcement officer, marijuana possession, and interference with government property. It also does look like he has an arrest from North Carolina, but I didn't see a disposition. We are asking for a $2,000 secured bond to have. We did make contact with the victim in this case. They do share 4 children together, ages 2 to 10 years old. They do communicate and co-parent today. So we are asking for no further violent contact, no alcohol, drugs, or weapons while out on bond, in a 1-day anger awareness course.
And this case is over a year old, correct?
Yes, Your Honor.
Okay. Mr. McLean, do you object to a signature bond through pretrial services, 1-day anger awareness, and no further violent contact?
We do not.
All right. Defendant is going to receive a $2,000 signature bond through pretrial services at level 1 per judge. He is going to have no further violent contact with Ms. Walker. Ms. Walker, if you're present, if you wish to make a brief statement, this is your opportunity. Please turn on your camera and raise your right hand. You are not required to make a statement. However, if you wish to do so, this is your chance. Okay. Defendant's going to receive a $2,000 signature bond at level 1 through pretrial services, $1,000 on each count. He's to have no further violent contact with the alleged victim. He's going to take the 1-day anger awareness course, have no alcohol, drugs, or weapons, and he will be reset further notice since I'm allowing him to sign his own bond. Is there anything additional from the state or from the defense?
Nothing.
All right. Best of luck to you, sir. That concludes your case for today. All right. Who do we have next?
Next, we have position number 16, Mr. Green.
Okay, good afternoon, Mr. Green. Your case is 25 CR 006057J. You're charged with harassing communications and terroristic threats. You understand your rights?
Now,
All right, Mr. Howard.
It's 3rd. I got an interference with custody. Let's see, this 1, 2. I got 2 interference with custody. One of them got a contributing to delinquency of a minor. Delinquency or dependency of a minor. And shows he's a resident of West Columbia, South Carolina. That's all. That's
Okay,
based on the booking sheet.
thank you. Mr. Rose?
Yes, Your Honor. He was just in jail on September 26th, dealing with the same charge and same victim. He was released on bond on September 27 with a bond condition that he has no further contact with Eva Smith. When he was released, despite that directive from the court, on September 29th of this year, Milton Police Department officers got a call from the mother of the victim, whose name is Sierra Smith, stated that her daughter was sent 2 text messages by Mr. Green, and that the first one pretty much said to her, you set up the face palm emoji, and the second text said, do you still want to talk, girl, or something to that extent. The victim and this Mr. Green they're no longer together. He is her ex-boyfriend, but he was arrested days prior for harassing communications against the same victim after making several phone calls 1 o'clock in the morning and sending intimidating text messages. Some of the messages even threatening to shoot up the home of Miss Eva and her mom, and also to shoot her brother in the face. He'd also made statements about in the text messages about having other people to assault and beat up Miss Eva Smith, who is the victim in this case. And so, given that he was arrested on September 26th, was given, I believe it was a surety bond, Your Honor, on September 26th, bonded out, and was told to stay away and not to have any further contact with that same victim. Obviously, that didn't sink in, and obviously he decided to defy the court's order. The state is asking for a cash bond in this situation, a $10,000 cash bond, and to have no further contact with Eva Smith, finally to have no contact with Eva Smith. And hopefully that would sink in, Your Honor, and that is no contact by way of phone calls, text messages, smoke signals, third parties, computers, SOS messages, no contact, no contact. Thank you, Judge.
I appreciate the creativity with the smoke signal there, Mr. Rhodes. All right. Is Ms. Smith present and wishes to make a statement? I don't see anyone with that name. Ms. Pinto?
Thank you, Judge. Mr. Green is 18 years old. He does reside in South Carolina with his father. So he should be able to abide by any stayaways, and hopefully any no further contact provisions. He does have one child that was just born a week ago. He also has family in Georgia, a mother and an aunt. He's a senior in high school. He plays football after school. Pretrial recommended a signature bond at level 2. We would ask for a bond not to exceed $2,000.
All right. Do we know what his last bond was? Does anyone know what that one was on the prior case? Let me see if
I can look it back up, Your Honor. I believe
I'm
it
trying to
was.
see myself. Okay. Defendant's going to receive a $5,000 surety bond, $2,500 on each count. He's to have no contact with Ms. Smith whatsoever through any form of communication. He's to have I can't do that since I didn't put him on free trial. All right, he's to have no alcohol, no drugs or weapons, and he's reset to all purpose on the 14th. Is there anything additional?
Nothing from the Your Honor.
All right. Best of luck to you, Mr. Green. That concludes your case for today. Who do we have next?
Next we have petition number 21, Mr. Hinton.
All right, Mr. Hinton, good afternoon. Your case is 25 CR 006066J. You're charged with improper passing, hit and run, and driving while your license is suspended. Do you understand your rights today?
Nah.
All right, Mr. Howard.
Hold on, I was reading his email. He went to felony earlier, got a $33,500 bond.
33.5?
Correct.
Okay.
We got 15 total. He got an open pretrial case, simple battery, 2 counts, battery. It's 25 CR 000138J. I think that got surrendered out of the felony. That was an open 25 PI case for obstruction, no insurance, reckless driving. Possession of tools, some other stuff. I got a 2020 battery DV conviction.
Okay. All right. Thank you. Mr. Rose, this was an accident as well?
This was an accident, yes, Your Honor.
Okay.
The state is asking for just a $2,000 total bond, 1,000 on count one and 500 on the other two counts. In light of the fact that he does have two open cases and he does have the felony case as well, we're asking for a good bond and that he's to do no driving without a valid license.
Okay. Ms. Pinto?
Thank you, Judge. Mr. Hitton's 30 years old. He's lived in Atlanta his entire life. He has 6 children, ages 11, 9, 8, 7, 6, 5, and 3. His whole family is here in Georgia. He's a graduate of Penn Foster High School and is currently at Atlanta Tech getting a barber's license. He also works as a tattoo artist. So he has very strong ties to the community. His current bond is $600 per count. He can't really pay anything, Judge, especially given the significant felony bond. So he would ask for a signature bond or $200 per count.
All right. Defendant is going to receive a bond of $750 total. Total 250 per count. He's not to drive unless he has a valid license issued by a state Department of Driver Services. He's to have no alcohol, drugs, or weapons, and he's going to all purpose as well on the 14th. Is there anything additional?
Nothing for the state, Your Honor.
No, Judge.
Best of luck to you, sir.
Can I ask what's the all-purpose for the 14th?
That's the next calendar. You can speak with your attorney further. They'll just revisit your case if you don't make bond, okay? All right.
Was that surety or
That's a surety bond. It's 750 surety, 250 on each count. There should be 3 counts, correct?
Yes.
Yes, okay.
Yes.
All right, next we'll go with position number 19, Mr. Hancock.
Okay. Okay. Mr. Hancock, your case is 25 CR 006062G. You're charged with battery. You understand your rights?
No.
I'm sorry, was that a yes?
No.
All right, thank you. Mr. Howard?
40. On probation, criminal damage to property, first degree. 24 SC 003971. Possession of cocaine with intent, possession of drug-related objects, 23 SC 188448. 2025 probation, 24 failure to appear. 2013 and 12 failure to appear.
Okay, thank you. All right, Mr. Rhodes.
Yes, Your Honor. To kind of summarize the warrant in this case, this incident happened on September 30th of this year. The victim in this case is a Roderick Powell. Roderick Powell, I believe, is going to be buying some marijuana from the defendant who apparently deals drugs. And when he went to hand him the money, he plummeted him and he bludgeoned him. Not only did he grab him from behind and punch him excessively, but he also kneed him in the face. When the officers came, they did see the injury to Mr. Roderick. They said what they described was that his eyes were almost swollen shut and he had multiple bruises to the back of his head, contusions almost, and that he was beaten up pretty badly because of how Mr. Hancock used his knee to strike Mr. Roderick in the face. He used his fingers to try to gouge out his eyes. It was a pretty bad, unprovoked kind of ordeal, Your Honor. As such, and from what you heard of the defendant's criminal history, we are asking for a good bond in the amount of $5,000 and that he has no further contact with the victim, in this case, Mr. Roderick Powell, and that he stay away from the incident location, which was 3601 Martin Luther King Jr. Drive, Northwest in Atlanta. That was a store. The clerk at that store did have video, and they did provide the video, and the video corroborated what Mr. Powell had told officers to happen, and so did the clerk. Thank you, Judge.
Thank you. Is Mr. Powell present and wishes to make a brief statement? Okay, I don't see anyone with that name. So Ms. Pinto, please proceed.
Thank you, Mr. Hancock's 43 years old. He's lived in Georgia his entire life. He has one child, 13 years old. His whole family's here in Georgia. He did go to the 9th grade. So he does have significant ties to the community. He does not know the alleged victim, so he's happy to stay away and have no contact. Pretrial recommended a signature bond at level 3. Mr. Hancock can't afford a bond, so we would ask for a signature bond.
All right, defendant is going to receive a $2,500 surety bond. He's to have no contact with Mr. Powell and stay away from the incident location. He's to have no alcohol, drugs, or weapons, and he is also going to state all purpose on the 14th, whereby aspects of his case can be revisited. Is there anything additional from the state or from the defense?
No, Judge.
No, Your Honor.
Sir, if you have a question, the best thing to do for you to do so you don't interfere with your right to remain silent is call your attorney. What is your question very briefly?
Okay, I have a question. Did I receive the signature bond?
You didn't get a signature. You got a surety.
What's that?
I'll explain it to you. I'll explain. You're good. Next, we'll go position number 39, Mr. Troutman.
All right, Mr. Troutman, your case is 25 CR 006032G. You're charged with making terroristic threats. I think there's 2 counts of that, and criminal trespass and damage to property. You understand your rights today? All right, thank you. Mr. Howard?
He got an open pretrial case. Simple battery, 2 counts, 1 count battery, 1 count fray. It's 25 CR 000830G. I want to say that happened before the last arrest, so I'm not going to surrender his bond on that one. I got a 2019 assault battery conviction. But I think the warrant in this case was issued late February, and he was here February on the pretrial charges.
So the
But I
pretrial was
guess
after this one?
I want to say yes.
I think that sounds right, Judge.
So that's why I didn't draw up
Okay.
the bond surrender.
Okay.
I think they wrapped the investigation up like the end of February for this right here. Yeah.
And his case before that would have been early February or something like that. Okay. All right. Thank you, Mr. Howard. Mr. Sirocco?
Thank you, Your Honor. This incident took place. This was February 4th, 2025 at 293 Love Street, Southwest Atlanta. Law enforcement responded to a dispute call, made contact with the victim. There's a few victims in this. The first is Miss Tequila Bolton. She explained the defendant is her child's father. They used to live together. She was receiving texts from the defendant on that day, and there were a lot of them. She found that they were threatening in nature. It showed the defendant threatening bodily injury to her and her mother, Miss LaDonna Bolton, the other victim here, who also used to live with the defendant. Texts included BITCH, I'm going to show up, and you just watch. T's gonna get real wicked, and I'm definitely it's a bit
I
all
think
over
we
the
got
place.
the flavor of
Yeah.
that. Yeah,
All
I
right.
think we know what was said.
It's
I
a
got you.
lot more of that. Thank you for cutting me off.
Yeah. Yeah, thank you. Let's not
Yeah.
say something by mistake, okay?
So the two had arrived home roughly 4 p.m. and found that their windows had been broken on the house. This was the house belonging to Miss LaDonna Bolton. So that's her property. And there were videos showing a male walking away from the side broken window, throwing things around in the yard, walking a silver sedan. He gets a tire iron out of the vehicle and walks back onto the property and around to the back before returning. The defendant was identified as the person that was doing that. The was further identified via his driver's license photo and confirmed. Um, we have spoken with one of the victims here, Miss Takayla Brown Bolton. It's T-A apostrophe K-H-A-I-L-A. Miss Bolton, regarding the case, she expressed that things have been resolved. She herself expressed that she wants the charges dropped. We will nonetheless be proceeding as they are the state's charges. She relocated to her mother's house, she stated, while she and the defendant were broken up, and this resulted in frustration on the part of the defendant after assuming the victim was ignoring him and not allowing him to speak to the children when in reality she was at her job that day. They share two kids, 1 and 2 years old, respectively. They have since reconciled and they have attended separate anger management sessions and counseling before getting back together. So they are back together presently, it looks like. She said things just escalated due to the defendant believing she was ignoring him like his prior child's mothers. And on that, I'm not sure what the exact relationship is with the victim in the other open case. It does appear to be some incident involving jealousy. The woman's name is Miss Classy Fields. Defendant saw text messages on her phone, started shouting at her, and then punched her several times, also pushing her, I believe. And as you heard, he has that domestic violence conviction from 2019. That's out of South Carolina. Given the open case, given the prior conviction, there is a risk of reoffense here. We are concerned for the safety of the victim, both victims here, both LaDonna and Takayla. The state's recommendation, accordingly, is a $5,000 surety. We're recommending $2,000 for each terroristic threats and acts charge, $1,000 for the criminal trespass and damage to property. We're recommending 2-day anger awareness at this time. No further contact with either victim. Stay away from 293 Love Street, Southwest Atlanta, and no drugs, weapons, or alcohol while out on bond.
All right, Ms. Bolton, I see you on the screen. If you'd like to make a very brief statement, please unmute and raise your right hand. Statements are not required. There will be other proceedings. This is just a bond hearing today. Please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
I swear.
All right. All right, please proceed. Again, we don't need you to get into the facts today. I'm most concerned with concerns you have for your safety, whether you wish to have contact with that person. Please proceed.
It was a misunderstanding. Him and my mom have talked. We have talked. We've been together for a month now. I really wish I didn't let people project on my relationship and told me to go that route. I understand I was scared at the time because I've seen him in all his seasons and I never seen him like that before. And at the time, people were telling me this is what I should do and da 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 da. And I just
Okay, is there anything else you'd
that's
like
all.
me to know? Okay, I appreciate you coming to court and making that statement, okay? All right, Mr. McLean, please proceed.
Your Honor, he's a high school graduate. He's an electrician. He works with his cousin who has an electrician company. Right now, they happen to be out of contract, so he's unemployed for the moment and therefore cannot afford very much at all. But he hopes that they bid on some contracts and they hope they're coming through, so they probably will. They have been to counseling already. We would ask the court to consider a signature bond.
Okay, and this offense date was back in February. All right, defendant is going to receive a $1,500 surety bond. He's to have no further violent or harassing contact with the alleged victim. Is it contended that was the state requesting a stay? I'm assuming there was a stay away requested. Does he
Yes, Your
contend?
Honor.
He doesn't live there though, correct? So, I am going to require that he stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional from the state or from the defense?
What's the contact level?
No, no further violent or harassing.
Thank you.
But I did put in the stay away, all right?
Yes.
All right. Best of luck to you, sir. That concludes your case for today.
And if we could, it was a for, in terms of SAP, could we make sure to add the open case here? 25 CR 000
Probably need to.
G.
Can you send Mrs. Rockwell, just to make sure it happens, will you please send an email to Mr. Jordan so that we can
Absolutely.
make sure that that case gets added to SAP? Because if I'm not sure that it will happen if we just say it now.
I hear you.
I appreciate you. All right, who do we have next?
Question number 33, Mr. Sparks.
Mr. Sparks, your case is 25 CR 006042E. You're charged with unlawful squatting. Okay, that's a new one. Do you understand your rights today?
Yes.
All right, Mr. Howard.
26. He got an open case 25 SC 005 834. Ag assault, criminal damage, second degree. Simple assault, family violence, obstruction, cruelty in the third. I got an open felony forgery in the first 25 PI 008077. Theft by conversion 22 SC 182232. 2025 obstruction. Another 2025 unlawful squatting. That's it.
Thank you, Mrs. Sirocco.
Thank you, Your Honor. I did see that unlawful squatting case from this year. It looks like that was dismissed. I don't know why necessarily, but it was dismissed. There is, um, sorry, pretrial. Did you mention the open cases that he has in Fulton?
I did.
Okay, great. The this was a which one are we starting with here? Actually, we got the unlawful squatting on July 22nd.
Oh, he also has an obstruction. My apologies, sir. I
Mhm.
didn't see that you're 3425 CR 006043E. You have an obstruction case. Let's treat them as, and let's do them all together, Mrs. Sirocco. Let's do them as if they were one case. If you want to give me any pertinent facts as
Yes,
we,
Your Honor, and
if
that
we
makes a lot
can.
of it makes sense to do so. So let's do it. The that unlawful squatting, law enforcement have responded to 5558 Union Point Place in Union City. Law enforcement was dispatched there in reference to a dispute, and there was they made contact with a complainant, Miss Maya Marshall. She's a representative of the property management company that owns that the building there, and that is First Key Homes Property Management. She received Ring camera notification at the address. It's supposed to be vacant, the at least the unit there, if it is in fact an apartment complex. But there was the defendant was observed entering the rear window and knocking down the Ring camera. He has a history of unlawful occupation at this location and is known for squatting at the property. Excuse me, and yeah, he could not substantiate that he had any a current lease agreement to live there, yet he continues to return there. And then September 30th was where the, excuse me, officer, yeah, uh, he was requested to leave the property. Officer returned to it was at that same location. He had been evicted from the location since December 16th, 2024. So he shouldn't be there for some time. Defendant refused to provide any evidence that he lived there, didn't have any, and there were outstanding warrants for his arrest that the officer found. When the officer tried to detain him, defendant started to flee on foot and ultimately had to tase the defendant in this case, ultimately complying, but not at first. The state's recommendation here is a $500 surety for each case for a total of $1,000 surety between them. We are asking for a stay away from the 5558 Union Point Place address in Union City. We think a social worker visit might be appropriate here for housing and potentially BHET, depending on whether defense thinks that's appropriate. No drugs, weapons, or alcohol while out on bond. And that is all for the state.
Okay, thank you. Mr. McLean?
Your Honor, he's 43 with a high school education through the 12th grade. He has a forklift certification, and he also has certifications or licensing that is sufficient for him to drive the truck and to operate and drive the cherry picker. We did not go into enough detail about why he felt he had authority or legal rights to 5558 Union Point Place. But apparently it was under an impression that he could, and whether or not he's mistaken, we'd have to research that. I have to drag out my old real estate book. We would ask the court to consider a signature bond. He does get mail through the Union City Post Office. General delivery at Union City Post Office works just fine for mail delivery for him, so he's not going to miss court.
Okay, one question, Mr. Howard, going back to history very quickly. The unlawful squatting that was in the history, it is this case, right? There's not
No,
two of, oh, it's a different one.
It was a
I think
different one.
Sirocco said it was dismissed.
Yeah, it was dismissed. I just didn't, there wasn't a rationale as to why it was dismissed from what I saw. So that's what
I just wanted to make sure it wasn't like a reactivation of that same.
Mm-mm.
Okay. All right. Defendant is going to receive $1,000 surety bond, 500 on each case. He is to stay away from that location, have no alcohol, drugs, and weapons. And his cases are both going to all purpose on the 14th, whereby aspects of the case can be revisited. Is there anything additional?
Not from the state, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Next we have position number 1, Mr. Hayes. No, add-on, I'm sorry, add-on number 1.
There's an add-on?
It's only one on there. I gotta go print mine off.
Thank God there's only one.
I do have a history though.
I
They were on the pull sheet.
Okay. Give me a second. Can Miss Bridgewater, can you assist me? What is the I don't think anybody
I didn't even know it was an add-on.
I don't
God.
have the add-on calendar.
It came.
I believe you. I just
Ugh.
when did it come? We must have been in court.
I've got-
Okay, I see it now. Mr. Hayes, your case is 25 CR 006072J. You're charged with theft or loss of theft of mislaying property. You understand your rights? All right, Mr. Howard.
Third. 2011 battery DV dismissed.
All right, thank you. Mr. Rhodes.
Yes, Your Honor, $3,000 signature bond, pretrial services level 1. No further contact with the victim. In this case is Nicholas Perry. They worked up there on Ponce de Leon together. And he, book bag with some stuff in it, laptop, cell phone. If the court is inclined, I'd like to have him take an anti-theft course because I'm going to eventually offer diversion in it, and that would be what I would require. So he'd be working towards that condition. And at this time, I'm going to ask that he stay away from 675 Ponce de Leon Avenue. I know the defense is probably going to say he works there, but I don't know if he's still working there after the theft. But I ask that he stay away from 675 Ponce de Leon Avenue here in Atlanta, Georgia.
Okay. Ms. Pinto.
Thank you, Judge. We are asking that he be allowed to return to the location because that is where he works. He's worked there for 8 years for the parking at Ponce City Market. He denies the theft allegations. It's his job to clean up the parking deck and discard anything that was left there. The case was investigated internally by his job. He was found to have done nothing wrong and does still work there. So it would be a significant detriment to him to not be able to return to his place of work. He is 56 years old. He's lived in Atlanta for 12 years. Pretrial recommended a signature bond through the jail. We would ask for a signature bond as well.
All right. Mr. Hayes is going to receive a $5,000 signature bond through the jail. I'm not going to require the anti-theft course. However, Mr. Hayes, you have heard from the state that that's what they intend to offer you. So it'd be to your advantage to get engaged and begin taking that class. He's to have no alcohol, drugs, weapons. I'm not going to exclude him from that place if he is still employed there. If he's no longer employed, then he must stay away. He's to have no alcohol, drugs, weapons. And he'll be reset further notice in light of the signature bond through the jail. Is there anything additional?
No, Judge.
No,
All
no,
right.
thank
All
you.
right. Best of luck to you, sir. That concludes the case for today. Who do we have next?
Next we have the waiver cases.
Okay. Were there other announcements from the jail regarding cases we weren't going to take up today?
Yes, position number 38 is reset because of behavior. Position number 3 is reset because of a conflict attorney that
he declined to come even though he knew he could get a bond set today.
yes.
What number was that?
Number 3.
Let me go back to 38 just for a moment. We have been resetting this case, seems like forever.
Okay. So has anybody at the public defender's office made any headway with position 38?
No headway, Your Honor. I met him on the first day. He refuses to come to court.
Okay, for Friday's calendar, can a phone be taken to there so we can get him off of the first appearance calendar? Is that possible at the jail?
Yeah, we could try. We can try.
Okay, because even if he doesn't engage it, we can do it with as long as he is present, if that makes sense. And it'll be me on Friday again. So
Yeah, we can try. We'll definitely try.
Okay, all right. So we're gonna start the
And I think one more. We have position number 11. Bond was paid.
11. Oh, they bonded out.
Yes.
And Judge, I had a question. There was a Goodwin on the pull sheet who I don't see on the calendar.
Do we know what happened? Did that case get NOD'd?
Yes, Your Honor. That case was NOD'd. It looked like there was an additional charge that was still holding him, also beyond the statute of limitations. So that was also NOD'd. He should be good now.
Yeah,
Okay, because last I looked, he was still just being held on it. Okay, it says not on docket. So.
And the party that says Amy Duncan, what case are you here for? Please answer quickly so we can start the wave cases. Okay, no response. All right, we're gonna take up. Okay, yes, ma'am. What case are you here for?
She put in the chat Lewis, Judge.
I don't know what case that is. Is there a Lewis on this calendar?
No.
There's no Lewis on this calendar, ma'am.
Did we have a Lewis?
Did we have another? I don't see anyone with that last name. All right, ma'am, I'm
that
sorry.
was Sparks's first name. I don't know if she means Lewis Sparks.
I think so.
Okay, well, ma'am, either way, we've already addressed that case, or
He said yes. So yeah, we did Sparks.
okay. All right, yes, we've addressed that case. All right. Take care. And if you have additional questions, you can interface with his attorney at a later time, okay? All right. Thank you all for your patience. Let's take up position 17 is a waiver, correct?
Yes.
All right, we're gonna take up the waive case of Ruben Grisham, 25 CR 006059Y, in which the defendant is charged with criminal trespass.
37. Last was 2011 sale of marijuana, 4 counts. 2011 FTA. 06 burglary conviction. Jail.
In light of the FTA, it's jail? Okay.
FTA. Oh, it's 2011.
I don't think
I don't know the
okay.
rule with the FTA. So
Yeah.
I thought it was
Okay.
like within 5 years or something.
I don't believe so. All right, Mr. Rhodes, please proceed.
Yes, Your Honor. As it relates to this case, Judge, this is a criminal trespass at 1700 Stanton Road, the apartments there. Uh, Thought I looked up the name of the apartments. I'll try to find the name of the apartments.
It's okay, as long as we know the address, it's not a medical facility.
That's right, 1700 Stanton Road, Southwest Atlanta, Georgia. And apartment A2, he had been called there before, and several other apartments where basically every time he goes to a different apartment, he damaged the property to the apartment. And so essentially, uh, you know, the person that was going to do repairs to this apartment saw him in there, and he had just been in there September 29th. And so, and they pretty much gave him a criminal trespass warning and notice then. That with the damage of the property, Your Honor, we are asking for a $20 good bond and that he stay away from the 1700 Stanton Road, Southwest Atlanta location, and that he receive a social work visit for housing, because we do believe that that's what he's ultimately looking for, housing, as well as a social work visit to assess whether or not he needs a BHET or MHET.
That was my next question. Is this, Ms. Pinto, is this your case?
Yes, Judge.
Do you think he needs evaluation for our 11 o'clock calendar?
I have no indication that he needs that.
Okay, all right, please proceed with your position regarding this matter.
Thank you. Mr. Grisham did just want the court to know that he had to waive appearance due to an issue with his back, not because he doesn't care what happens. He's 66 years old. He's lived in Atlanta his entire life. All of his family is here, including one child who is grown. He did graduate high school. He is not working. He receives disability due to back issues that cause paralysis. He's okay with a stay away. Pretrial reported no failures to appear in the last 2 years. They did recommend a signature bond at level 3. I will note that there is an address on file that he reports is a good address where he can receive his notices. So we would ask, he's not able to post anything monetary for bond, so we would ask the court for a signature bond.
All right, defendant is going to receive $1 cash bond. He's to stay away from that location, have no alcohol, drugs, or weapons, and he will be reset to all purpose on the 14th. Should he not make bond, I'm not going to require that he meet the social worker before release if he has the dollar. But I am going to ask that the social worker visit him if he's still there. Is there anything additional from the state or the defense as it pertains to this case?
Oh, that's all we
No,
have.
Judge.
All right. What was our next waived position? Is it 28?
Yes.
Someone help me. Yes, brain is slowing down by the second. All right. We're going to take up the waive case of Charles Roberson, 25 CR 006038B, in which the defendant is charged with obstruction. Ms. Howard, can we have his history?
8, homeless. 2023 violation of family violence order that was dismissed. 22, simple battery DV. 19, battery trespass. 19, theft by taking NOLO. 2010, battery DV, false imprisonment.
I'm sorry. One more time. Was there any obstruction?
No. I mean, if it was before 2010.
It doesn't matter. I need to know if any obstruction keeps him from getting SOB. All right, Mr. Sirocco.
Yes, Your Honor. I, for one, didn't see obstruction, if that's any comfort to the court. The state's recommendation here, this was the defendant kept returning to this. It's the Fulton County Northwest Library. It's at 2581 after being formally banned from the library. He wasn't on the actual property. He was near it. They reported it. And when the officer arrived, he
He's
gave him
homeless.
verbal command stop and ultimately fled on foot, tried to conceal himself beneath a nearby bridge, and was ultimately located under that bridge and arrested. State's recommendation is a signature bond through pretrial services. We would recommend a social worker visit for housing. stay away from the Fulton County Northwest Library. We think would be a good idea. 2581 Hollywood Road in Atlanta. And no drugs, weapons, or alcohol while out on bond.
Okay. Mr. McLean, you're muted.
Other than suggesting an NOD, we've no objection.
Does he have a good address?
He gets his mail,
Homeless.
an organization called Power something on Lowry, but I haven't been able to Google that yet to get the exact address. I
So
asked him if he was Veterans Empowerment on a different road, which I'm familiar with, but it wasn't that one. But it does have the name Power in it, and he says it's on Lowry.
Okay, so we're just gonna assume more than likely no good address for right now. Defendant is gonna receive $1 cash bond. He is, I guess, to stay away from that library, even though it's not charged as criminal trespass. And have no alcohol, drugs, or weapons. I'm gonna ask the social worker to see him as well, but not require that as a condition of his release. And he's gonna be reset to state all purpose on the 14th. All right, is that our last case? Nope, it is not. Position 30.
Sorry, Your
No.
Honor, what was the dollar amount again? For,
It's just $1, $1. All right, is there anything additional on that case?
No, Your Honor.
Okay, now we'll go to the next. Is number 30 is a waiver, correct?
yes.
Okay, and is that our last one?
No, we have 42. Ricky Williams.
Okay.
We have Peters and Williams both.
We're never going to finish, so you keep asking.
Okay, I'm sorry. Position 30, 25 CR 0060334Y. The defendant is charged with criminal trespass. In this case, Mr. Bruce Sanders. All right, Mr. Howard, can I have the history, please?
16. He got open shoplifting from the city. Open manufacturing meth out of South Carolina. On probation for PI and obstruction. 25 CR 004 064Y. Let me see. I got 2 trespass convictions from this year, one from 2022 failure to appear, and a 21 terrorist threats conviction. That's it.
Thank you. Mr. Rose.
Your Honor, based on the history, I'm asking for a $3,000 good bond that he stay away from 2907 Main Street in East Point, Georgia, 30344. To believe that this might have been the CVS store, Judge. And I don't feel like the factual basis. I'm tired too, Judge.
Only CVS only I there's
29.
a
Yeah,
no, I
CVS.
get it. It's a hybrid medical kind of place. Is Mr.
I
McLean,
got
does
you.
he have prescriptions or something that's coming to that location that he would need to return there? I understand it's not quite a hospital, but before we
The
completely
reason
ban
they,
him from there.
I would say the reason they criminally trespassed him was because he was previously told not to be there due to previous thefts. Prior thefts,
Okay.
he had at least 10 prior thefts at that same store. So even
Okay.
if not all CVS's, at least if he could stay away from that one.
That one.
Right.
Okay. Mr. McLean, any other
Yeah.
thoughts?
Mailing address is 201 Washington, which is a program that we're familiar with, and they do good mail service there. That program is very efficient. He has a year of college animation. He's certified for forklift, and he's unemployed at the moment, but he hopes to get another forklift job soon.
Okay. Defendant is going to receive a $10 cash bond. He's to stay away from that CVS in its entirety. If he has prescriptions there, he must transfer them to another location. He's to have no alcohol, drugs, or weapons. And he is reset to all purpose on October the 14th. Is that correct, Ms. Bridgewater? I'm assuming yes. Okay.
That's
It
correct.
is. That's correct. Thank you, Ms. Young. Okay.
I apologize on
No,
behalf of the other two.
it's okay. This is okay. So number 42 is the last position, Mr. Ricky Williams.
On this last one, are we off streaming now?
It's the charge is criminal trespass. Is there a reason we should be off streaming? Let
It'll,
me go look at the warrant.
it'll be MH.
Oh, and I do want to ask, there may have been an announcement already, but this was, I don't recall presenting on that of the four individuals with the Rice Street jail incident. I know we didn't hit one of them. Was one of them a waiver?
One
Or
of them said he refused. He's gonna wait till Friday for a conflict. That was position 3.
okay. Thank you, Your Honor. Appreciate
All
that.
right, so let's go ahead and take. So Mr. McLean, are you requesting a breakout for this one?
Well, just that it not be public, I think is sufficient. I think everybody's in the courtroom is gone, right?
All right, can we? There's somebody that's Zoom user that we don't know quite who that is. So out of an abundance of caution, just very briefly, can we go into a breakout session for this last case? Before we do that, Mr. Howard, give us the history. 25 CR 006064Y, the case of Ricky Williams, in which Mr. Williams is charged with criminal trespass. Mr. Howard, give us the history, then we'll briefly go into a breakout.
This history is not brief. 68 total. We got an open trespass. What else? We got an open possession of drug-related objects. On probation, battery in a public transit vehicle or station. On probation for trespass. Uh, on probation for obstruction and trespass. On probation for another trespass, pedestrian roadway obstruction. On probation for another battery in public vehicle or station. Trespass, certain acts on bus or rail prohibited. On probation for another trespass. I'll leave it at that. 68 total though.
68 total, mostly trespass.
Yeah.
All right. If we could very briefly go into a breakout, Miss Young.
Chanel, you'll let me in?
All right, defendant Williams is going to receive $1,000 surety bond. He is to stay away from MARTA in its entirety, consistent with the permanent ban. He'll be reset to state all purpose on, what was it, the 16th, Ms.
The
Bridgewater?
16th, yes, ma'am.
On the 16th, not the 14th. And he's to have no alcohol, drugs, weapons. We are going to ask that a social worker come and visit him as
How much,
part of his prior to release.
how much was that?
1,000. Okay, have we addressed every case? Please say that we have.
Your Honor, you said 10/16, the comp calendar?
No, we're not putting him there yet. We're just putting him
Okay,
10/16
it's only
SAP.
16.
And
Okay,
we're hoping that it can go to the 11 o'clock, but we're not gonna put him there yet.
Did Holly
You,
freeze up?
No, I'm here.
Oh,
Miss Young, you weren't with us in the breakout? You should have come with us. My bad. All right.
Was Stowers on a full sheet today?
Who?
yeah, he was. We didn't
Miss
do him
McLean,
though.
don't give us any more work. Who's missing?
Stowers.
Clinton Stowers.
Does anybody know
Um,
what happened to Clinton Stowers?
hold on, I think I have good news for you. Yes, I NOD'd that case.
Stanley too.
We did Stanley, didn't
We
we?
did. Oh, okay.
Didn't we do Stanley?
I probably walked away. Ain't no telling.
Very good. Thank you.
Yeah, we did Stanley number 35. Miss Bridgewater, did we skip any before I have you review?
We can catch it when I review, Your Honor.
Okay. Thank you all for your patience. Miss Bridgewater, thank you for your patience today. Will you please review this calendar for us?
Okay, once again, the reset date for the SAP calendar is October the 14th. Position number 1 is reset further notice with a total $4,000 SOB through pretrial. Position number 2 is going to the SAP calendar for October the 7th with a total $1,000 good bond. Position 3 is reset to Friday, October the 3rd. Position 4, SAP calendar, going back to October the 14th with a total $1,000 good bond. Position 5 is reset further notice with a $2,500 SOB through pretrial per judge. Position 6 is reset further notice with a $2,500 SOB through pretrial. Position 7 reset to the SAP calendar with a $2,000 good bond. Position 8 reset further notice with a $2,500 SOB through pretrial. 9 is going to the SAP calendar with a $1,000 good bond. 10, SAP calendar with a total $1,750 good bond. 11 is reset further notice. The defendant was released. 12 is going to the SAP calendar with a total $1,500 good bond. 13, SAP calendar with a total $1,500 good bond.
No contact.
On
15.
13,
13. Yeah.
I have no further contact and stay away from the victim's residence.
I'm sorry, what question, which number are you asking about?
13.
13.
Just the contact.
Yes, that's what I have as well.
Okay, we're moving on to 14. 14 is reset to the SAP calendar with a total $2,500 good bond. 15, SAP calendar with a total $2,500 good bond. 16, SAP calendar with a total $5,000 good bond. 17, SAP calendar with a $1 cash bond. 18, reset further notice with a $5,000 SOB through pretrial. 19 is
That's per judge too.
This one is per judge, okay? Position 19 is going to the SAP calendar with a $2,500 good bond. 20, SAP calendar with a $1,000 good bond. 21, SAP calendar with a total $750 good bond. 22, reset further notice with a $3,000 SOB through pretrial. 23, reset further notice with a $3,000 SOB through pretrial. 24, SAP calendar with a total $2,500 good bond. 25, reset to the SAP calendar with a $1 cash bond. 26, reset further notice with a total $3,000 SOB through pretrial. 27, SAP calendar with a total $3,500 good bond. 28, SAP calendar with a $1 cash bond. 29, SAP calendar with a $5 cash bond. 30, SAP calendar with a $10 cash bond. 31, SAP calendar with a $10 total cash bond. 32, SAP calendar with a $1,000 good bond. 33, SAP calendar with a $500 good bond. 34, SAP calendar with a $500 good bond. 35, SAP calendar with a $5 cash bond. 36, SAP calendar with a total $2,500 good bond. 37, SAP calendar with a total $3,000 good bond. Paper's getting stuck. Position 38 is being reset till Friday. 39, reset to the SAP calendar with a total $1,500 good bond. 40, SAP calendar with a $1 cash bond. 41, SAP calendar with a total $1,750 good bond. 42, SAP calendar set for October the 16th with a $1,000 good bond. 43, SAP calendar with a total $1,000 good bond. 44, reset further notice with a total $2,000 SOB through pretrial.
Hey,
45,
Judge.
What?
Yes.
Okay. What number was that?
44.
44.
Okay, I'm fine with that, per judge.
Okay. 45 is going to the SAP calendar with a total $2,000 good bond. And the add-on is reset further notice with a $5,000 SOB through the jail. Are there any questions?
Number 19, Ms. Bridgewater, Mr. Howard, you said that one was per judge as well?
19. Is that Hamilton?
No.
Which one did you say per judge?
18. Hamilton.
Mm-hmm.
Oh, because she has to open. That's fine. Okay.
Okay.
All
Are
right.
there any others? Okay. I don't know whether or not Zoom is still going, but if we can come off the record, if Francois